Good morning, everybody. Good morning, good people. Good morning, good morning, good morning. We got four people in the chat today, and I'm still like I feel like I'm behind, so I need to get all of our little things in place. We don't have a poll up yet or anything. All right. Yesterday, interesting day over there at the Diddy trial. Not gonna lie, I was, was amused and entertained with David, James, and the Punisher's testimony yesterday. I'm not even gonna lie. The Punisher's book was hilarious. Okay, where to find freezer meat? How hard is it? Hilarious, hilarious. Uh, but essentially, yesterday the prosecution had a really good day over there in the Diddy trial. If you ask me, they got across some pretty damage. They got some pretty damaging things across to the jury or over to the jury. Um, or maybe we should say put in front of the jury, right? Um, that really I think helped their case, in my opinion. All right. Today we are back over on the Karen Reed trial, and yesterday in Karen Reed was a hot mess. Burgess, you know, had his education misrepresented on a resume. He's been pursuing a bachelor's degree of general sciences in mathematics and business administration or something. A degree that does not exist at the school that he claims that he went to. He alleges that it's supposed to say general studies and mathematics. However, it's been wrong for the 17 years he's been having it on his damn LinkedIn resumes and all the other places. He was also refuting a lot of other testimony that is to come and has come from other people who've also examined the card data. What clicked for me yesterday, I actually had to have somebody tell me, is that I can understand what the point of the 3-point turn was. And that's probably because I listened to Karen Reed with probably like 65% of my ears. The other 45% of the time I'm doing something else and not paying attention to it because it really gets on my nerves a lot of the time. But I figured out that I was told that the 3-point turn is really the baseline that they use to try and calculate the time in which the collision allegedly occurred. And a lot of the testimony from Burgess is the one who wanted to put the 3-point turn at a time that would be before the locking of John O'Keefe's phone, which was done manually. So I found that out yesterday, which was very interesting. And so it basically, now Burgess's testimony is all coming together for me because essentially he's saying he got this time, but everybody else's time is a little bit different. But either way it went, I still don't think it fits the prosecution's theory. Like, I think that their theory is still gone to shit. So I don't know what the hell Brennan is doing. I guess we just have to sit and wait and see what happens. We've been on this for 3 weeks now. This is supposed to be, they say this trial it may last 6 to 8 weeks, but I honestly think that Brennan is closing in on his case. I don't think he's really got much more to present, in my opinion. I think that if anything, Brendan may be resting. If not the end of this week, we don't have court on Friday. So if Brendan don't rest tomorrow, I can definitely see him resting next week. My opinion. Okay. All right, I think that's all I can give y'all right now. All right, so we're gonna keep our same ebb and flow. Y'all know we're gonna read the tweets. I will post what's happening in the Diddy trial from the NBC News website into our chat and pin them so folks can read up on it as we watch or listen to Karen Reed. And then when the time comes, I will scurry on over to the Inner City Post so we can get a little bit of the transcript, right? We can get a little bit of a verbatim of what's kind of being asked and what's being said over there in the Diddy trial, right? So, Yeah. Okay. Let me be quiet because now I'm losing my train of thought, y'all. I need to eat breakfast because, yeah. Cam say Brother Love is going to jail. I don't doubt it. I don't doubt it at all. Good morning, Tina. We're just patiently waiting for the Commonwealth, who is not ready today. They're not ready today. But I guess that's why she told Christina yesterday, yeah, I'm gonna have you come in here a little later. How you come back tomorrow, but a little bit later. Okay, maybe we got a little action. We got a little rumble going on. Not at all, y'all. I do wonder what type of I'm gonna close it. You know, I didn't even check that the thing was in the right setting. Y'all, so I was going through it looks like the YSL trial part 2 is probably going to be the last trial I get to stream with everybody. Like I'm kind of it's a bittersweet moment because I'm going to law school. So yeah. But I'm also like I'm a little sad because I really enjoy streaming with the folks. So I think that'll be our last streaming trial that we do, and then for anybody who's a member, I'm gonna be releasing some that is so mean to I don't like how they being mean to Zoe. But anyway, I think for some of the people, so if you are a member of Taylor Gang, I am going to release some law school content exclusively for y'all. So I'll be showing y'all like me in class, like doing like those get ready with me a day in the life. I don't think I'm gonna post that publicly. So I will post those for y'all for members, and then I'll post some over on TikTok as well, but it won't be the same content. It'll be exclusive for our members. And then I may have to switch up our content over here because I do still plan on being able to be up to date or up to speed on some of the things that are happening. So I may just have to record and post, and they may shift our channel a little bit, but I have to figure out a way to stay engaged because I don't want to fall off the face of the earth and not know like what is going on with these trials, with these lawsuits. One of the things that I was also thinking about when we was talking about the Diddy trial on TikTok Live was what the hell happened to the dude from Abercrombie and Finch, because he too was charged with very similar charges to Diddy. But of course, a little different. He's an older white male. And I saw our girl Mel, I'm not a lawyer, but post a video about it. And yes, apparently his charges well, not his charges have been dropped or anything like that, not yet, but they saying that he is unable to stand fit for trial because in his case they say that he was linking up with people, telling people that they had to do private parties in order to young men, saying that they had to audition and do these little private parties in order to catapult their modeling careers. But these little parties weren't the parties that you think of. They like Diddy parties.
You are unmuted.
That's what they say, baby. He got Alzheimer's.
All right, could I see counsel at sidebar, please?
Here we go with this. Y'all just got in the door. I don't even understand why Court TV chooses to take the daggone unmute the daggone mic, because at this point we understand every morning they're going to the damn sidebar. Talking about a damn sidebar. John's mama get on my nerves. She do, and the faces that she make, I think that she should be instructed not to be able to make faces. All right, I gotta head over to this other call.
All right, so let's bring the jurors in, please.
Leave it for now. rise to the court. Jurors entering. Please be seated.
Good morning, jurors. So an issue has come to my attention that is going to make it necessary that I talk to each one of you individually over at sidebar with counsel. So that process will take a little while. So I'm going to don't speculate as to what I'm going to talk to you about. Please, when you go back to the deliberation room, talk about anything but this case, and I'll see each of you individually. And the process may take time. The cameras will be shut off, and I'm going to talk to the lawyers about whether we clear the court. No filming.
Oh, hot damn.
Send you back and then send you back.
Oh, y'all. So it's the woman over in the courtroom. I'm about to go over to her.
Now I'll see counsel.
It's the woman that's over in the courtroom. And I'm going to go over to her page. Yeah. Because, baby, hold on. Somebody say Chris Brown has officially been granted bail. I didn't think that I thought that Star told us that bail is not a thing over there in the UK. Child. I'm trying to go find the woman. All right, let me see. I'm looking for that lady because what the hell did happen with the jurors, y'all? I'm trying to find her. I think somebody might be getting dismissed. They might be swapping in an alternate. Baby, who in the courtroom? Let me make a post because who in the courtroom at this point? Okay, boom. There's a jury issue. Judge tells the jury an issue has come to her attention that makes it that she needs to speak with each juror individually at sidebar. So the people won't even be able to hear what questions she's getting ready to ask them. Child. Okay, y'all. Let me see if I can find us a little something to watch in the meantime, in between time, because baby, wait. And if something pops up on Twitter, I just read it off. We got a criminal docket we can watch. Okay, well, that one ain't working. Let me see if it's another one. Infamous. Okay, Dear Question is live right now. Talking about the Great Noya breakout. I knew Corey was gonna be the next one. Everybody say Derek is gonna be the next one to get caught, y'all. I don't know if y'all keeping up with that or not. Okay, we got Judge Cedric Simpson is live. We can watch his criminal docket.
Run this form.
I understand.
All right. You understand that you're giving up your right to appeal of right.
Yeah, I understand.
All right. Are you on probation or parole?
Yeah. I understand.
That's beyond bond.
Okay.
Yeah.
Are you under the jurisdiction of any other court?
No.
All right. Have you ever been to prison for longer than a year?
Okay.
Have you ever been to prison?
Yeah.
Have you been to prison
The president, well,
in the United States? Have you ever been to prison? Not jail, prison.
yeah.
Okay. Counsel approach, please.
Hey, little mama.
Record should reflect that it had a bench conference with counsel. I'm going to stop the plea at this time. I'm going to adjourn this matter out June 4th, 2025, 9 a.m. And we'll take care of submission. All right.
Thank you, Your Honor.
Thank you. Bond will continue. Court does call the case of the people versus Sarah Orr.
Testimony for the people.
Sherilyn Foster Tucker on behalf of Sarah Orr.
Or Your Honor.
Thank you. All right. What,
Read first.
briefly, yes. Never going to get through this. In fact, we've had a bench conference in this case.
Yes, Your Honor, and there has been an offer extended to the defendant to plead to an added count of failure to report $1,000 damage accident, 90-day misdemeanor, $100 fine, and 0 points, contrary to MCL 257622. In exchange for that plea, count 1 will be dismissed.
That is correct, Your Honor. And Ms. Ward does wish to accept that offer today. And I have handed the court an advice of rights form.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Sarah Orr.
No. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of failure to report an accident. It's damage over $1,000. That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes.
All right. Understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You
Sorry.
signed an advice of rights form. Is that correct?
Yes, I did.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
Because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On May 22nd, 2024, at the location of Moon Road near Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
All right. Were you involved in an accident?
Yes, Your Honor.
What happened?
So I was in the yield lane or the merge lane, whatever it's called. And the other guy was in the through lane and we were at the red light. And when we were driving through, I got in front of him and then he got into the turn-in lane. And then he says he was gonna turn, but I don't think he was because the way the damage is, he hit the front of my car and the front of his car. So he was trying to get back in front of me.
You're
But then
heading,
we collided.
you're heading north.
Correct.
You were heading toward Ann Arbor.
No, away.
You were heading away from
So
Ann Arbor.
south.
So you were coming past the Walmart,
Yes,
heading out.
right. Where State Street turns into Moon Road.
Yeah.
Yeah.
Okay. All right. And so you had this collision. Did you immediately stop your vehicle?
I did not. I was a little scared, so I did not.
Okay, you didn't stop. Did you immediately report that to the nearest and most convenient police
I did
station? Did not. Would you dispute that the aggregate amount of damage that can include repair cost was in excess of $1,000?
For mine or for his?
Total.
So you obviously don't know how much his vehicle.
Right, correct.
But would you dispute that if he says it was more than 1,000, would you dispute that?
I didn't see the damage, so I don't know.
We can stipulate that it
You'll
was over
stipulate that
1,000.
the damage, total amount of damage to both vehicles was in excess of 1,000, including repair costs. You'll stipulate to
Yes.
that, counsel. All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
June 25th. At 9 a.m.
June 25th, 2025, 9 a.m.
And Your Honor, I do not expect a restitution. I do believe the insurance covered everything.
Covered everything. Okay, fantastic. All right. Thank you. All right, bond will continue. You'll stop down at probation on the way out. Just to
Okay.
check out. All right.
Okay, thank
Thank
you.
you, Your Honor.
Thank you. Court does call the case people versus Michael Klustra.
Ashalani for the people.
Morning, Anna Uwe Das with and on behalf of Mr. Klustra, standing to my right. Mike, please state your name for the judge.
Michael Klustra. All right.
We have an adjourned plea trial, had discussions with Ms. Landi. Make counsel approach, please.
Yes, briefly,
Thank you.
folks.
Today's the day.
I got a whole
I
lot
know.
of cases
We're gonna bounce around because I don't know what's happening over there in his courtroom, in Cedric's courtroom today. Let's see what's happening in our other one of our other courts.
And state your name, or I'm gonna pass it until the end of the docket today.
Please say your name, Miss Smith.
Ms. Smith, please say your name.
She looks frozen.
Right, I'm passing it. You need to reach out to your client and maybe get her on to a better device or something.
I mean,
I think so, Your Honor. I'll give her a
no,
call.
that's not the act. I think the point here is that we have that selector there. So this is just
What we'll call the
you
case is
mark it up doesn't make
Ypsilanti
it
Township
yeah,
versus
that's
Jeffrey
a better way
Murphy. Case number is
getting this done.
2014-00-131,
I'm okay with that. If we want
as
to use the
well
same
as
component and figure out a way to put those topics on it, I'm good with that.
23W002569B.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Mr. Murphy. Mr. Murphy, could you say your name, sir?
Jeff Murphy.
Thank you.
Okay.
All right. We're here today on a violation of
Yes.
probation. I'm gonna arraign you on your violation, sir. The violation alleges that you failed to drug and alcohol test on May 1st, May 7th, and May 12th. You have a right to have a hearing on the violation, at which time, if it is found that you violate the terms of your probation, you could be sentenced up to 10 days in the Washtenaw County Jail. Well, actually, this is your third violation, and so you could get the maximum penalty. In this particular case, you're charged with OWI, so the maximum penalty is up to 90 days in the Washtenaw County Jail. Mr. Lebo, what would your client like to do?
Your Honor, Mr. Murphy is being held on a felony matter that is currently pending. I'd like to adjourn the probation violation until after the preliminary examination on his felony, which is scheduled for the 27th.
Why would I do that?
In order to determine if the felony is going to continue to hold and which may affect his decision regarding the violation.
Mr. Barnett?
I'll leave that up to you. I mean, I don't want him out, but he's not gonna be out.
When is the examination?
The 27th, Your Honor.
I will do that, but I'm gonna set a bond in this particular case.
Mr. Murphy, do you understand that?
Yes.
I'll adjourn the matter to May 28th. Is it for the actual exam or is it for the PP
It's
conference?
Your Honor, that case not being held by my office, but I spoke to Mr. Murphy and he told me that it is for the exam.
Okay.
And was that June 28th, Your Honor, or May 28th?
May 28th.
Thank you.
May 28th, 2025 at 10 o'clock a.m. How long has he been in custody now?
Your Honor, I can check that right now. Mr. Murphy, I believe you've been in
Since
custody
April
for around
20 since April 29th.
Oh, okay.
And he does have a $100,000 10% bond in the felony, Your Honor.
All right. I'm gonna give him a 2,500 10% bond on this one.
Thank you, Your Honor.
All right, sir, we'll see you back here on May 28th, okay?
All right, thank you.
You're welcome.
Yep.
Did you say something to me? The court will call the case of Ypsilanti Township versus Victoria Johnson, case number 24T00462.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Johnson. Ms. Johnson, can you state your name, ma'am?
Good morning, Your Honor. Victoria Johnson.
Good morning, Ms. Johnson.
Morning.
All right, we're here for a pretrial today.
Yes.
We're here for sentencing.
Oh,
Yes.
you're right. I'm sorry, for sentencing.
And Your Honor, I have
Uh-huh.
reviewed the report and recommendation with Ms. Johnson. I do have one factual modification as well as some allocution argument. With regard to the factual modification, the report indicates that the police responded to a report of a locked vehicle in the park. That should read to a vehicle locked in a park.
Oh, okay. I was trying to figure that out.
As was I, Your Honor.
So that's why she was trying to go through the gate.
Yes.
All right, I will make that change.
Thank you, Your Honor.
Well, I should say the objection, Mr. Barnett, is that how? you
No,
do-
that's exactly what happened, I believe.
Thank you. As far as elocution is concerned,
As far as elocution, Ms. Johnson understands that operable intoxicated is extremely dangerous and that she's fortunate that she wasn't harmed, that no one else was harmed, and frankly, that her vehicle wasn't further damaged, there wasn't any further damage to other property. I do want to note that the crash that occurred here was essentially Ms. Johnson bumping into a post or a bollard on her way out of the park. It wasn't hitting another vehicle or hitting anything occurring at a high rate of speed. It was more of a maneuvering incident trying to leave the park. This is not a high BAC case. The assessor indicates there's no substance use disorder, so I'd be requesting no probation or non-reporting probation given that. I'm not entirely sure why the assessor believed it was necessary here, but I don't believe the presumption of a non-probation, non-jail sentence is overcome in this case. So I would be requesting that the recommendation be adopted with the exception of the probation and testing recommendations, Your Honor.
Mr. Barnett.
Your Honor, I've also reviewed the pre-sentence investigative report. I don't have anything factual to address. I'm just thinking about what Mr. Lebo said, but I do support the recommendation, including the probationary period. It was recommended by the assessor. They're in a better position to understand what would be appropriate, and I'm going to defer to their expertise on that. So I would ask you to follow the recommendations.
One moment. Well, the reality is whether it was hitting a baluster or any other device, it was a crash involved. So there is nothing needs to be overcome because there was a crash. That doesn't apply in crash situations.
Yes, Your Honor.
One second, I'm just reading the assessor's report more closely to see why they thought it was necessary in this case, other than there being a crash.
Thank you, Your Honor.
And Christina Barry Darian requesting permission to practice pursuant to Michigan Court Rule 8.120 under supervision of Assistant Prosecuting Attorney Ashley Lonnie.
I won't embarrass you by going through the series of questions. I did that the other day. I know where you're from, where you are, right? You're at Wayne State, right?
Yes.
Okay, good school. You like Wayne State? No. You do? Okay, we'll let her practice. Permission to practice is granted.
Your Honor, Christina Barry Darian for the people. Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Can you unmute and state your name for the record, please?
Candace Brooks.
Okay.
You know, we are requesting an adjournment. Just want a little bit more time to talk to the people about a potential offer.
Hearing no objection, I'll adjourn this matter June 4th, 2025, 9 a.m. Thank you. Court calls the case of the people versus Jason Brooks.
The people. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. Oh, thanks. Please state your name.
Jason Brooks.
Thank you, sir.
Your Honor, I am requesting an adjournment. I was unable to speak with Mr. Brooks prior to today. I'll get updated contact information, just make sure we have the right number for him before he leaves the building.
All right, June 4th, 2025, 9 a.m.
Thank you.
Thank you, Mr. Brooks. Court calls the case of the people versus Zachary Burlett.
Ask the line of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burlett, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Zachary Burlett.
There he is, okay.
Thank you, Your Honor. I have discussed this matter with the people, and it was my understanding that this was going to be a dismissal. Oh, sorry.
What did she say?
Just getting my notes pulled up. Your Honor.
Oh, okay.
One moment, to clear off my screens. That's correct, Your Honor. We are going to be dismissing this case.
So certainly no objection to that.
Case is dismissed. All right, thank you, Mr. Burlett. Take care.
Have a good day.
Thank you, Mr. Burlett.
Court does call the case of the people versus Justin Goltowski.
Ask the line of the people.
Assistant Public Defender Natalie Pate on behalf of Mr. Goltowski, who I do not believe is present, Your Honor.
He's in.
Oh, he's in Zoom. Perfect. So my message got to him.
State your name, sir.
Justin Goltowski.
Thank you.
Thank you, Your Honor.
You're probably gonna need an adjournment.
I am respectfully requesting an adjournment. I was able to speak to, I believe it was his roommate yesterday, so I'm glad the message got passed along. That is excellent news. But I do need to talk to Mr. Goltowski himself regarding his case, so I'd ask for an
June
adjournment.
4th, 2025, 9 a.m. All right, thank you, sir.
I got a phone number for you. For my attorney, if you don't mind.
What'd you say?
I have a new phone number for my attorney, if you don't mind.
I don't want you broadcasting it that way.
Okay.
So you can call the clerk's office and give it, or let me give you the public defender's office number.
Okay.
It's area code 734.
Yep.
222-6970. Call them, give them your updated phone number, as well as making sure that your email that they have is correct, and then you'll be all set.
Okay, yes. Thank you, Your Honor.
Thank you.
Thank you, sir. Thank you, Your Honor.
Court calls case of the people versus Isa Awad.
Ashley Lundy for the people.
Isa Awad.
Your Honor, this should be Ms. Deborah Ford. I don't.
I'm here.
I'm here.
Who are? Okay.
I'm here.
Oh, there's Miss Ford's here.
Yes, Deborah Geraldine Bledsoe Ford on behalf of Issa Awad.
All right. And Mr. Awad?
Yes, Your Honor.
All right. I need you to turn on your camera, state your name.
You saw why, and my camera's not working. Give me 1 second. I fix it.
Okay, well. All right, what, and Miss Ford, you can verify that that's your client?
Yes, that's my client.
All right, what are we doing?
I'd ask that the matter be continued to June 18th. I would at 9 appear in person. My client has stated all along that he wants a jury trial, and I'd like to talk to the other side and see if we can negotiate anything. If not, then go further.
Can't do that by the 4th?
I feel it would be a strain.
June 18th, 2025, 9 a.m.
Thank you very much.
That's gonna have to be in person because he doesn't have a camera.
I'll be in
So
person.
that hearing's in person.
We will be in person. Thank you.
Thank you.
Thank you, Your Honor.
Oh, no, let's get this done. Court calls. Cases of the people of the state of Michigan versus Jason David Allen. All 9 of his files.
Ashley Lundy for the people in all matters.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Allen, who should be present via Zoom from Don Parham. Sir, can you please unmute and state your name for the court?
Jason Allen.
Thank you, Your Honor. There is a resolution of all 9 of these matters today, Your Honor. I don't know if Ms. Lundy would prefer to put the resolution on the record, or I could do so.
I am happy to do that. Your Honor, chart 22410696. The defendant will plead no contest to this charge to retail fraud in the 2nd degree.
Hang on, which case?
696.
696, he's pleading no contest
As charged.
as charged. All right. Got it?
698.
Yes. He's doing what?
No contest to an added count for retail fraud in the 3rd. Just count 1, count retail fraud 2nd.
That's no contest to that charge also.
Yes,
They're all no contest
yes.
from the reports I read. Okay, I hope they are. All right. Go ahead.
697.
Yes.
They'll be pleading no contest to an added count to a retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
All right. Okay.
328.
Yes.
With no contest is charged to retail fraud in the 3rd degree.
Okay. Okay.
And lastly, 278.
Yes.
No contest to an added count to a retail fraud in the 3rd degree, dismissing count 1 retail fraud in the 2nd degree.
Okay.
Case 699. And don't please, dismissal cases now, 699.
700 and 2419, and then 218 would be dismissed.
That's correct. Restitution for all cases and all counts.
So basically, he's pleading to 5 counts of retail fraud 3rd degree.
1 retail fraud 2nd, 4 retail fraud 3rds.
Okay, hang on a second. Got it. Okay, and 696, he's pleading to retail fraud in second degree.
Exactly right, Your Honor.
Why, I don't know, but is that correct? Is that a correct statement?
Yes, it is, Your Honor, and that is what I discussed with my client, and that is what he would like to do today.
All right, Mr. Allen, raise your
Yes,
right
Your
hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name for the record, please, sir.
Jason Allen.
All right. Mr. Allen, it is this court's understanding that you are going to be pleading no contest to one count of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
And that also you'll be pleading no contest to 4 charges of retail fraud in the third degree. Those are misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. You understand that?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about a no contest plea is that I have to make sure that you understand is that first of all, it means that you're not further desirous or wanting to contest any of these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea in these cases.
Potential civil liability, Your Honor.
All right. So, sir, to the charge of retail fraud second degree, how do you plead?
No contest, Your Honor.
To the charge of retail fraud third degree as contained in the case ending in 698 with an offense date of March 12, 2024, how do you plead?
No contest, Your Honor.
To that same charge of retail fraud in the third degree contained in the case ending in 697 with an offense date of March 17, 2024, how do you plead?
No contest, Your Honor.
To the charge of retail fraud third degree as contained in the case ending in 328 with an offense date of 8/29 of 2023, how do you plead?
No contest, Your Honor.
To retail fraud third degree as contained in the case ending in 278 with an offense date of November 27, 2023, how do you plead?
No contest, Your Honor.
All right, now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
All right. Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am a participant of Judge Conkey's drug court.
All right, so you're on probation. Well, were you on probation at the time of any of these offenses?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will?
Yes, Your Honor.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report in the case ending in 696, the report number 23-14001. In the case ending in 698, the public safety report and case number 244086. In the case ending in 697, court has reviewed the police report 244362. In the case ending in 328, court has reviewed the police report and Case number 23-12936. And in the case ending in 278, court has reviewed police report ending in 2318100. Since I've read all those, counsel, is there any objection to the court having reviewed those reports?
No, Your Honor.
No, Your Honor.
All right, the court in each of those reports does find a sufficient factual basis in which the court could find the defendant guilty of the offenses as alleged for sufficient evidence of defendant's guilt in those cases. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas in all of these cases to count 2 or to retail fraud second in case 696, and in the other matters to retail fraud third. The other cases, as indicated on the record, are no longer with me. Those matters are dismissed. All
Thank you,
right.
Your Honor.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in these matters will be June 25th, 2025, 9 a.m. Defendant's bond in all of these cases will continue. Mr. Allen, I need you to wait online. We're going to put you into a breakout room with my probation department so that we can begin the sentencing process. Okay, sir?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Allen.
Thanks, Natalie.
What's all that? Court does call the case of the People versus Lisa Keebler.
Ashley Lonnie for the people.
It's only 9 or 10.
Nine.
Oh, yes, I see that.
Good morning, Judge. John Shea with and on behalf of Ms. Keebler.
Your name?
Lisa Keebler.
Thank you.
May we approach?
Yes.
Thank you.
All right, let me see if I can swap out and get us to a place that's got some audio. We're doing a little roulette today. Keep us entertained while we wait for whatever's going to happen in the current retrial to occur.
It
looks like
Sentencing in this case will be on June 18th, 2025 at 10 o'clock a.m. Ma'am, did you write down the phone number when I gave it out earlier today for the probation department?
No, I couldn't hear anything.
Okay. Do you have a pen now to write it down, ma'am?
Yes. Just one second.
Okay,
734-483-7336.
okay.
All right, please call them tomorrow after 9 o'clock and schedule an appointment to have a precedence investigation report done. And then when you come back here, they'll write a report for us.
Okay.
All right.
All right. Thank
The
you.
other 2 tickets are dismissed and you are all set. Have a good day.
Okay. Thank you.
You're welcome. The court will call the matter of Ypsilanti Township versus Martez Tullis, case number 22T00695.
Paul Barnett on behalf of the township.
Matthew Mansour on behalf of Mr. Martez Tullis. Martez, can you state your name for the judge, please?
Martez Tullis.
Thank you. All right, Mr. Tullis was before me on May 14th when he pled guilty to the new charge of OWI second from March 13th. I adjourned it for 1 week for him to be an inpatient or 60 days extended probation. But they're recommending 6 months to test within 24 hours. And did he go test?
Yes, I did.
And what's the status of your treatment, sir?
I did my intake on this past Friday and Sunday. I'm sorry, this upcoming Friday, she'll have openings. I'm going in at 10, which is the 23rd. At the Amherst House on Linwood. I sent the number and the address to Mr. Mansour.
Yes, he did, Your Honor. And Your Honor, I went over the report with Mr. Tullis. You are exactly correct about the last hearing. We want to thank you so much, you, Mr. Barnett, and probation for allowing him to have the opportunity to check himself into the program. He has checked himself. He is scheduled. He's locked in. He's good to go. He's going to be there on Friday at the
10.
Yep, at 10 at the Elmhurst home in Detroit. He's thankful for the opportunity. He's excited to get started and, better himself and work on himself. And the best part, Your Honor, you allowed him to do it on his own. You gave him the chance. He did test within 24 hours. He did get into the program, and he did square away everything he needed to do with his family. So we're going to go in there. We're going to come out with a better perspective on life, work on problems that we have or don't know we have, and come back to you with the review date. And was it 30 to 60 days? I don't know. But when we come back, we're going to
I'm not following the recommendation, just so you know.
Oh, uh-oh.
I want to see him in a week to make sure he's in that program.
Oh, yeah. That's no problem, Your Honor. That is no problem.
I'm going Friday morning, Miss Washington.
I know you told me that, Mr. Tullis. You also
I was trying to go this past Friday, but she didn't have no availability open because all the people that I guess she got in there. So she told me Friday, but she just texted me like while we're on Zoom now to confirm the appointment. So I replied back with the letter C to let them know that I confirmed for the appointment and the intake.
Mr. Barnett, any input on this one?
I'll leave it in your discretion, Your Honor.
All right, we'll see you back here on May 28th, 2025 at 10 o'clock a.m.
Okay.
Defendant to be an inpatient at that point.
Yes, ma'am.
If he's inpatient and they can't bring him, Mr. Mansour,
Yep.
you need to get something from your client giving you permission to get a letter from them indicating that he is an inpatient, okay?
Gotcha, Your Honor. And Martez, please keep me updated. If they say you can't have your phone in there or whatnot, please call me so I know exactly what to do so I can provide it to the court and everybody.
You should
Okay.
have an ROI now so that we have that. Because once he gets in there, if he doesn't have his phone, you can't reach him. So I don't know how you're gonna effectuate that, but you need to get that done so that I can have those proofs. Because if I don't have the proofs, I'm issuing a bench warrant.
Okay, Your Honor, the ROI it's through the inpatient treatment program, right? Or is it through
It
probation?
could be, no, or it could be, I don't know if the PD has their own form, I don't know. But you guys have to figure that out.
Okay.
We'll do that, Your Honor. Thank you so much.
Thank you.
Thank you.
You're welcome. We'll call the matters of Dominique Johnson, 24T00382, 20T00515, and 24T00446. Nope, just those two.
Paul Barnett on behalf of the township.
And Matthew Mansour on behalf of Mr. Johnson. Dominic, can you state your name for the judge, please?
Dominic Johnson.
Thank you. Mr. Johnson's here for a payment plan review and a sentencing.
Yes, that is correct, Your Honor. I went over the report with Mr. Johnson. We have no additions, deletions, or modifications. We are aware of the restitution amount. Mr. Johnson, all he asks is if he can get into, when it's appropriate, to a payment plan at the minimum right now because he's struggling financially.
Thank you. Mr. Barnett?
Yeah, I've also reviewed the pre-sentence investigative report as well as the recommendations. I support the recommendations, including the restitution amount.
Thank you. Anything you want to say, Mr. Johnson?
Yes, ma'am. I do. I would like to say that I am deeply sorry for the loss of the animal and that the dog bite would even happen. I would like to take full responsibility because if I was out there watching, that dog would have never got hurt. It wouldn't have got attacked or anything. So I do apologize for that dog being attacked and it losing its life. So please, for the court and to the victim, to please forgive me, and I do apologize.
Thank you. I think, what is the victim's, she might be here. I think Irene just entered into the there's a device that I just allowed into the virtual courtroom named Irene. Are you Miss Irene Smith?
Yes.
All right. Miss Smith, I just called the case. Did you want to have anything to say today? I think you missed Mr. Johnson apologizing, so he'll probably need to do that again. But is there anything you wanted to say today during the sentencing, ma'am?
So I was hoping to get, I don't know how I missed it. I was logged in, but since 9:50, but I paid out of pocket almost $2,000 for my dog. The day of the accident, I rushed her to the vet and we incurred some costs. And then she passed away 2 days later from the sustained injuries from the accident. And I incurred another like $600 or so dollars. So there was a total, there was a total cost here. And it was about $1,900 that I came out of pocket to bury my dog. So I'm seeking retribution for that as well.
So I'm
Um,
very sorry for your loss. I'm trying to find out what the total is that you're saying you think you're owed.
so I submitted the bills to the courts. So the first patient, the bill was $1,410.49. That came from Blue Pearl Veterinarians.
Ma'am, my question's still the same. What is the total amount that you are requesting?
That amount was for $543.25.
So is the
You're,
that you're
I'm so-
requesting a total of $1,953.74? Is that the total amount that you're requesting, Ms. Smith?
That is what I'm requesting.
All right, that is what is being recommended.
Okay.
Now, Mr. Johnson, because Ms. Irene Smith was not in the virtual courtroom at the time, I'm going to ask that you start over with your allocution so that she would at least have the benefit of hearing it. Okay.
Yes, I was saying that I deeply apologize for the incident that happened with your dog. Please forgive me for that. It was my responsibility to be outside watching my dogs. Didn't watch them. It had something happened to your dog, and I'm deeply sorry about that. Please forgive me from the courts and to you. And I don't have any more dogs anymore, so no one has to even worry about me with dogs. Period. So I do apologize to you, and I'm very sorry that that happened to your dog. Please forgive me.
Thank you.
Thank you. Anything from anybody else before I impose sentence?
nothing further from the defense, Your Honor. Thank you.
Not from the township, Your Honor.
All right, thank you. Sir, is the sentence of the court that you serve 90 days in Washtenaw County Jail, credit for 0 served. The balance of that time is suspended. You are non-reporting probation for 12 months. Fines and court costs in this particular case for a total of $425. You must pay restitution to Ms. Irene Smith in the amount of $1,953.74. You to complete a dog responsibility program as approved by probation. And we'll do a review in 90 days to make sure you've done those things. And that you have a payment plan that has been set up. The 90 days will be on August 27th, 2025 at 10:00 a.m. You also have an additional ticket that you're here for a payment plan review on. You need to incorporate that into your new payment plan. It was set up at $25 per month. I think because of the restitution, it will be increased. How much can your client pay per month?
Your Honor, right now we're struggling pretty bad, so as low as the court can go.
$50 per month payment plan. Well, the reality though is he won't be off of non-reporting probation until he gets this paid. So that's gonna be a problem.
That's understood, Your Honor. We're working hard to try to find a job right now. It's kind of getting some bad luck here and there, but we're staying positive and we're still trying. So we
Okay.
appreciate it.
All right, thank you. Sir, I'll see you back here on August 27th at 10:00 p.m.
Yes, ma'am.
Thank you.
Thank you.
You're welcome.
Bye.
Bye-bye. Court will call the matter of Ypsilanti Township versus Stephen Adolph, 24 T 00174.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Stephen Adolph. Mr. Adolph, can you please state your name?
Stephen Adolph.
Thank you. All right, we're here for a review today. It looks like Mr. Adolph finally on May 20th provided proof of his community service. And so the probation agent is willing to strike the violation of probation because of that. And he is recommending early discharge. Mr. Barnett, any position on that?
No objection from the township to that.
Thank you, Your Honor. And we do ask the court to follow that recommendation.
Defendant is discharged with improvement early. Thank you for getting everything done, sir.
Thank you.
And that means you don't have to ever see me again. Look at that.
Thank you so much.
Have a good day.
You as well.
Bye.
Bye.
Ypsilanti Township versus Mariah McClare, case number 20 T 00433.
Paul Barnett on behalf of the township.
Hey, Matthew Van Sewer on behalf of Miss McClare. Miss McClare, if you can, you state your name.
Mariah McClare.
Thank you. I know her camera's not that great, Your Honor. Mariah, can you try to put on your camera?
It is on. You can't see.
No, we see blackness, Miss McClare.
Hold on.
So she's here for payment. It looks like Miss McClare still, I'm sorry? I can see just a little bit. Miss McClare, you appear to be in a very dark room. We obviously can't see you if it's pitch black in there.
No, my front camera is broke. Like I have a light on right here.
Okay. Well, she's here for payment. It looks like Miss McClare still hasn't made any payments.
Yes, Your Honor. I spoke with Miss McClare yesterday. We apologize for that. Your Honor, we are working really hard to try to find a job. We're hopeful that she's going to land a job by this Monday. She's applying with a temp agency. If that all goes well, she'll be able to get her first check within a couple weeks, I assume. So if we could just give her to hopefully the first week or two of June. She understands that has not made a payment in a while, but she's really struggling as well. So if you could give her just another opportunity, please.
July 2nd at 10 o'clock a.m. For a contempt hearing.
Thank you, Your Honor.
Thank you.
You're welcome. But we'll call the matter of Ypsilanti Township versus Brian Foley, case number 22 T 00339.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Brian Foley. Mr. Foley, can you please unmute and state your name?
Yes, Brian Foley. I'm trying to start my video. Okay. It says can you see me?
We can, Mr. Foley.
Okay, Brian Foley.
All right, we're here for a quick call today.
Yes, Your Honor. Sorry, go ahead.
I'm doing okay.
Your Honor, we would be asking for what we think would be a last adjournment here. Mr. Foley did believe that he cleared his tickets in 14A1 and the 35th District Court, which I know we had talked about. He said he went to the Secretary of State and was told he still does have holds. So we need time to figure that out and for him to clear any additional holds.
That's because none of the tickets have been cleared and there were only two.
Okay. Go ahead, Mr. Foley.
Yes, Your Honor. That's what I seen at Secretary of State's office, exactly what you've seen. However, when I contacted 35th District Court, they actually told me they do not have any tickets on me. It is nothing there. They told me the Secretary of, excuse me, yeah, the Secretary of State came through and wiped all outstanding tickets clear. And that is the response that I got from 35th District Court. The other ticket, I don't know what it is, and the Secretary of State doesn't have anything. However, that I can go see where this ticket is at. 35th District Court, and I contacted them, and actually is there, and they actually have nothing whatsoever. And like I said, the response that I got back is that the Secretary of State came through during COVID and wiped everything clean, and that's what the response I got.
So when we were here back on January 29th, which has almost been 5 months now, at that time I went over what the tickets were and gave out ticket numbers as well. I'm going to do that one more time. So please write them down.
Just one moment. Let me find something to write with in here.
And Mr. Foley, go ahead and write them down yourself. I will write them down as well, okay? And
Okay,
I can
would you
also
please?
text them. I will text them to you, okay?
Thank
Your Honor,
you.
I will take these down.
35th District Court, ticket number 13C1 2747A.
I have that, Your Honor.
It is for failing to display a valid license from September the 15th of 2013. (14A) District Court in Ann Arbor. Ticket number 1518301334B. For no proof of insurance from July 22nd, 2015.
Thank you, Your Honor. I'll get these to Mr. Foley right now with case numbers.
What's going on with the security fail piece of this?
Your Honor, I'm sorry. I don't, let me see if we discussed that. We were very focused on the license and discussed that. I don't know if Mr. Foley and I have discussed his insurance. Your Honor, if we could adjourn that as well, and I'll make sure that we, if the court would be willing to give us the last adjournment, we'll resolve and figure out the insurance situation as well.
Mr. Barnett, what is your position on this?
Your Honor, that's fine. We can adjourn both matters.
This is the final adjournment.
I understand. Thank you.
June 18th at 9:00 a.m.
Yes, ma'am.
See you then, Mr. Foley.
Yes, ma'am.
Roll call the matters of Kathleen Serta, 21T11507, 21T11503, 21T11504, and 21T11506.
Paul Barnett on behalf of the township.
Ms. Serta, please state your name.
Kathleen Serta.
All right, we're here for hearing today. Are we having a hearing on this today?
Mr. Greenwood's here. We're ready to proceed.
Have you reviewed her letters?
I did. It mostly relates to communications that occurred after the date of these tickets. So I appreciate that they worked, to some extent after these tickets were issued, but I don't think it's germane to the issue of the tickets.
Well, that's going to take a while, so we won't be doing that first. I'm going to handle some shorter matters and then we'll have the hearing. Mr. Greenwood has reviewed those as well.
Yeah, I believe so. It's the same material, Tom, that you were sent.
Yeah, I'm looking at I was sent some of the notes, and it looks like I have some notes as far as like what happened on which dates or the results of some of my inspections. Again, I'm only privy to some of the information due to that I no longer work for Ypsilanti Township and don't have access to it. But I do show some dates and times of what violations existed.
Because it's
Mr. Barnett, the date of the ticket that I have is February 5th of 2021.
Correct.
And her correspondence begins in, well, the first one is 2020, and then after that is 2021. Where he was still talking about doing re-inspections after.
Well, and the issue is, there's still issues with the property, so they're not going to just issue a citation for failing to bring it into compliance and then just walk away. And I mean, it still has to be addressed. So, I mean, they gave her notice allegedly, and I guess we'll parse that out, but allegedly gave her notice of certain violations for 4 of these properties, and a date by which to bring them into compliance, and she failed to do that. and then issued a ticket for that in February of 2021. They continued to work with her after that. And I think that's where the
her issue is
correspondence.
whether she has notice or not. Okay, all right, we'll deal with that next. All right. Ms. Serta, please hang out until we're done with the shorter matters, and then we'll have your hearing. The court will call the matters of Nigel Blanton, case numbers 21W002669, 21W003187, 23W003558, 24W000404 A and B, and 24W001564.
Paul Barnett on behalf of the township.
Please state your name, sir.
Nigel Blanton.
Oh, I'm sorry. I can't see you well. You female? Thank you. I'm sorry. There you go.
Nigel Blanton.
I got you, ma'am. Thank you. All right. You are here for a contempt hearing today for failure to pay on your tickets, which, as I just read off, there are a number of them. Contempt means you should be, you need to provide to the court a reason why you shouldn't have to do jail time for failing to pay on your tickets. You owe $1,321 on the 6 tickets that you have before the court.
Well, that being said, I am dealing with 2 other court cases I'm putting money towards already. And I just paid $650 to get my license back. Paid 2 warrants, and it's just the job is slow. So I'm just, paying off one thing. I forgot about the tickets, honestly.
Ma'am, you failed to appear 3 times in front of the magistrate, although notice was sent to you, and you apparently get them because it's the same notice and you're here today.
I wouldn't notice because I'm really just moved. I've been dealing with a lot of stuff.
What I hear you saying is that other courts are more important than this court, that you have money, but you haven't made a single payment to this court. So I don't see any reason why you shouldn't have to do jail time, which what jail time works is you do jail time, and then when you come out, you still owe the money. You understand that?
Yeah.
Okay. So, Mr. Barnett, do you have a position on this?
Your Honor, I'll leave it in your discretion.
Mm. All right.
You can't hear?
Defendant is found in contempt. Okay. Ten days in the Washington County Jail. Ma'am?
Yes.
You're gonna need to do 10 days in the Washington County Jail. The way you reverse that is by making some payment on your fines and costs before we come back here next time.
You said 10 days in the county jail, or what did you said pay something before you come back?
Yes, I'm gonna reset these on June 18th at 10:00 a.m. If you haven't made any payment on your fines and costs, then you can do some time in the jail. Are we clear?
Okay, so pay something or I'm going to jail?
Correct.
Okay.
Okay, we're gonna cut this.
How much do you plan to pay, ma'am?
I can pay 25 today.
June 18th, 2025 at 10. You need to have that payment made, ma'am.
Okay.
We'll see you then.
All right.
But see, Shay, she got up there being arrogant, and what she should have said was that she had a lot going on. She trying to pay things off as she go, and she needed more time. But she got up there being real snarky, and she was like, you know what? Oh, wait a minute, Karen Reed is back.
Please be seated.
All right, so jurors, I still have a couple of questions for you. Were you able to follow the instructions and refrain from doing any independent research or investigation into this case? And we've discussed the other two questions, but I do need to stress for you that it's very, very important that no one discuss this case. Don't let anyone talk to you about the case, no comments about the case. You've seen how hard the lawyers have worked to pull this case together for you, and everybody's given it so much time. So please, let's make sure that we follow that. That means each other. So with that, I know we're late getting started. We're going to take an abbreviated lunch today, only 30 minutes, and abbreviated breaks. So no morning break. We're going to start now and go to the 1. All right, Mr. Brennan, and we're taking a witness out of order. I apologize. We've got a witness here. Sometimes we take witnesses out of order. Ms. Hanley will be back later for the rest of her testimony, but we've got a witness here that we'll call out of order. Thank you. Mr. Brennan, thanks.
Thank you, Your Honor. The Commonwealth calls Dr. Wolf.
Raise your right hand, please.
You solemnly swear the evidence you give to the court and jury in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
Good morning, doctor.
Good morning.
All right, whenever you're ready, Mr. Brennan.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spell your first name and last name for the court reporter?
Sure. My first name is Isaac, A-I-Z-I-K. It's phonetic. Last name is Wolf, W-O-L-F, like the real thing.
What do you do for a living?
I'm a brain surgeon.
Is there a special part of medicine that you study?
Well, my main interest in brain surgery is brain tumors and trigeminal neuralgia. But I also specialize in movement disorders. I do pediatrics and adults.
Are you an active working neurosurgeon?
I am very active working neurosurgeon. I get up every day at 4:30 in the morning to go to work, 5 days a week. I take call 300 days out of 365 days a year.
Did you work yesterday?
Yes, I did.
What type of work did you do yesterday?
I did 2 brain surgeries yesterday.
Are you working tomorrow?
I have 4 surgeries scheduled for tomorrow, which is why this is a little bit delayed for me, and I have 4 on Friday.
And what type of surgeries do you have tomorrow and Friday?
I have 3 brain tumors, 1 trigeminal neuralgia, and on Friday I have 4 patients with movement disorders.
You're here today as a witness. How much of your practice, how much percent of your income is from being a consultant or a witness for a case?
Probably less than 1%. I don't do this for a living.
I want you to take us through some of your education and background. Could you share with us where you went to medical school and where you graduated from?
I went to Yale Medical School. I graduated summa cum laude.
Was that in 1981 that you graduated?
Correct.
After medical school, did you begin internships in medical residency?
I did an internship at Hennepin County Medical Center, which is a trauma center in Minneapolis. I then did 5 years of neurosurgical residency at the University of Minnesota.
And was that in Minnesota?
Correct, in Minneapolis.
Is there something about that hospital that has some specialty?
It was one of the #1 training centers for chairmen in neurosurgery at the time.
Did you, in your residency and in your fellowships, do any work or study in pathology?
During your residency as a neurosurgical resident, you do 6 months in neurology, you do 3 months of neuroradiology, you do 3 months in pathology, which includes autopsies on brains. And then you do rotations through a trauma center as a chief resident, through a VA hospital, and then ultimately at the university hospital for elective cases. We also do 6 months of pediatric neurosurgical residency.
Did you do a fellowship at New York University?
Yeah, at NYU, I did a fellowship before I went to the University of Maryland as a professor in brain transplantation. The interest was in using cells to create dopamine centers in rat brains with the concept of Parkinson's being curable with transplantation.
I'd like you to take us through some of your faculty positions, and so you can share with us some of the progression of your training and experience. And did you begin at the University of Maryland Hospital?
Yes. In 1987, the University of Maryland recruited me to start their epilepsy surgical program and skull-based program. And then part of our responsibilities as assistant professors was to cover shock trauma.
Could you explain for us what shock trauma means and whether the University of Maryland Hospital was a shock trauma hospital?
So the University of Maryland and shock trauma were actually two separate entities when I started. A man named Cowley had basically developed the concept of the golden hour. So prior to Dr. Cowley, most trauma was just taken locally. That meant as a community hospital, if a patient had been in a motor vehicle accident, they needed an orthopedic surgeon, they had to call the orthopedic surgeon in, could take 15 minutes, could take 3 hours. The same thing for a vascular surgeon, the same thing for a neurosurgeon. Dr. Cowley came up with the concept that you needed a center that was strictly for trauma and every attending had to be in the hospital 24/7. So that was the concept of shock trauma back in the 80s. When I got there, we were transitioning from a very small center to a 125-bed hospital that was completely committed to trauma.
In that experience, in the years you worked there, did you have an opportunity to treat a number of people with brain injuries?
We treated well over 100 patients a year, a month, basically, with brain injuries at shock trauma, along with spinal cord injuries.
Did you perform surgeries in different types of brain trauma and brain injuries?
Yes.
After Maryland in 1993, did you move to Miami Neuroscience Center?
Yes. In 1993, I left academics. I went into private practice in Miami, and I started the Miami Neuroscience Center. We were the first private community hospital to have what's called the Gamma Knife. So we were the 13th in the country, but the only one that was non-university based. And Gamma Knife radiosurgery is using radiation to operate on the brain.
Are you presently the director of the Miami Neuroscience Center at Larkin Hospital?
Yes, I am.
Do you conduct a number of surgeries a year there?
Correct. So I spent 19 years at Doctors Hospital, then we moved to Larkin Hospital 13 years ago, developing the new radiosurgical unit called ZAP, and also another fancy machine called high-frequency ultrasound to treat the movement disorders.
You've noted that you have a number of professional memberships. I don't want to go through all of them. I'd like to point out a few. Are you a professional member of the American Association of Neurological Surgeons?
Yes.
Are you a member or fellow American of the College of Surgeons?
Yes.
Are you a member of North American Skull Base Society?
Yes,
And is that brain related?
it is.
Are you a member of the Society for Neuro-Oncology?
Yes,
Are you a member of over or at least 34 different professional memberships?
yes,
In your career, have you engaged in research?
yes,
Has that research focused or centered on brain injury?
yes, it has.
Is some of your research as a principal investigator for THAM treatment of brain tissue, acidosis, and severely head injured patients?
Yes,
Did that research and as a principal investigator help you in your diagnosis and treatment of brain injuries?
it actually was in the treatment of severe head injuries, patients who are unconscious. The concept of trying to relieve the increased intracranial pressure that occurs from the injury and to increase blood flow, thereby increasing oxygen to the brain.
Did you also serve as principal investigator for research for the PEG, SOD, and severe head injury?
Yes.
Could you describe that very briefly?
Basically the same, one of the biggest problems in brain injury is the fact that blood flow ceases to exist as the brain swells up. And so one of the things we try to do is preserve the neurons by making sure that they have enough oxygen and blood flow to them. All these are agents that try to assist that.
I won't go through all of your research and principal investigator roles, but I want to ask you about one more. And that is, did you serve as principal investigator relative to the IRB protocol for brain pathology?
Yes.
And what did that do? What was that about?
It was about looking at what happens after a brain injury to blood vessels and tissue as the intracranial pressure increases in the brain.
Have you been part of publications of a number of different books?
Yes.
I won't list parts of all 16 books, but can I point out a few?
Sure.
Were you the author of a book chapter regarding head injury, difficult medical management?
Yes.
Were you the author of a book chapter on pediatric neurosurgical emergencies?
Yes.
Were you the author of a book chapter on complications of head injuries in adults?
Yes.
Were you an author of a book chapter, Imaging of Craniocerebral Trauma?
Yes.
Were you an author of a book chapter in Emergency Room Assessment of the Head Injury Patient?
Yes.
Were you the author of a book chapter, Intracranial Injuries?
Yes.
I won't list or ask you about the other book chapters that you've been the author of. Have you been involved in journal articles?
Yes.
I'd like to ask you just about a few of the 70 journal articles that you have published.
Your Honor, objection.
So go ahead and ask the question without a comment, please.
Were you an author of a journal article, Intracranial Pressure in Non-Traumatic Ischemia and Hypoxic Cerebral Insults?
Yes.
Were you the author of a journal article, Post-Traumatic Cerebral Infarction?
Yes.
Were you the author of the journal Fractures of the Clivus?
Yes.
Could you tell me a little bit about that paper?
We used thin cut CT scans to identify fractures of the skull base. Prior to this, prior to CT scans, it was very difficult to actually identify radiologically a skull fracture with plain x-rays. The idea was to see if we could identify them more clearly. And so we classified them and delineated them in the paper and discussed the outcomes that were relative to those type of injuries.
In the last journal article I'll ask you about, were you the author of a journal article regarding acute traumatic midbrain hemorrhage?
Yes.
Were you the presenter in a number of presentations regarding head injury and brain injury?
Yes.
You've listed 93. I'll ask you just about a few. Were you a presenter in fractures of the clivus, clinical and radiographic features?
Yes.
Am I pronouncing that correctly?
Clivus.
Thank you. Were you the presenter in acute head injury?
Yes.
And a separate presentation, fractures of the clivus, classifications and clinical features?
Yes.
Do you lecture?
Yes.
Do you have peer-reviewed publications?
Yes. That was one of them.
And are you heavily involved in clinical research?
Right now, my research is more based on radiosurgical techniques and outcomes.
Over your career and your study and your clinical experience, have you treated different types of brain injuries?
Yes.
Are you familiar with a number of different types of brain injuries?
Yes, we still treat them.
Were you asked to review materials relative to this case?
Yes.
And do you recall the materials that you reviewed?
Yes.
Could you share with us some of the materials that you reviewed?
I reviewed the chief medical examiner's assessment of the case. I reviewed pictures that I'm assuming the medical examiner took of the autopsy. And I reviewed the report from the forensic pathologist.
And before I ask you about your review of specific materials and your opinions in this case, is there a benefit to your clinical experience in studying brain injuries as opposed to the experience you had as a fellow simply with pathology?
Well, I think that for the jury to understand is a clinician understands the process from the time the injury occurs till the patient either leaves the hospital or dies. And it's a process. And as a neurosurgeon, I have a tremendous amount of experience with that, if that's what you're asking me.
Yes. And so, doctor, you reviewed a number of items of information in this case. Did you have an opportunity to review photographs of a laceration to Mr. John O'Keefe's head?
Yes, I did.
With the court's permission, I'm going to ask to display Exhibit 160.
Okay.
Dr. Wolf, I'm going to ask you to take a look at this photograph. Have you seen this photograph before?
Yes.
I want you to explain to us what you're seeing here and take us through the process of your observations.
Well, what we're seeing is an approximate 1.5 inch laceration with bridging tissue and contusions and abrasions. To us, that's just a classic blunt trauma injury. There's nothing other than just vanilla about it. This is what happens when soft tissue hits a solid ground. The skin tears apart a bit, but not through and through. As you can see, there's the bridging. You can see all the bruising or contusions and just the tear, a little bit serrated along the edges.
Thank you. If you could take that down. Dr. Wolf, as a result of that wound, did you have a chance to further look at information provided to you about the actual inside the skull of Mr. John O'Keefe?
Yes, it was the pictures that I was reviewing showed a non-depressed skull fracture extending linearly through the clivus and into the frontal fossa of Mr. O'Keefe over the orbital roofs. He had fractures along the temporal fossa as well. So it was a classic linear basilar skull fracture.
Is basal skull fracture a characterization?
It's basically the base of your skull is what it encompasses. So the opening at the very bottom is what we call the foramen magnum that connects your brainstem to your spinal cord. And then as your brainstem goes up, it goes into the different skull areas that, talk about what we call the cerebral cortexes, your occipital lobe, your temporal lobes over here, and then your frontal lobes.
So can you walk us through what happens when someone incurs this type of injury to the back of the head, how it happens, and what are the next steps for a person?
So what happens is, you fall backwards, and the linear acceleration starts to take you back down with gravity. The skull hits the ground. It gets, in layman's terms, smashed a little bit. And then the brain moves forward as a response to that. And it moves forward because you have cerebral spinal fluid and because you have the deceleration, acceleration again. As it does, your skull, if you were to look inside your skull, it's like mini mountains along your temporal bones and your frontal bones. So the brain is being thrust forward at a fairly good speed, and it's getting bruised. You can think of it as if you took a hammer to your thumb. It's really turning black and blue. Those are the contusions. And so the temporal poles and the frontal poles are getting contusions because of that. At the same time, you have a space called the subarachnoid space. And I'm sure they're going to hear about the subarachnoid hemorrhage. And that space is it's very clear, thin membrane that covers all of your brain and all of your spinal cord. And normally, you really don't see it unless you open up the brain and you're operating. But when you either have a traumatic event like this, where little vessels are pulling apart underneath that membrane, or, for example, the classic, when you have an aneurysm burst, the space that the aneurysm bleeds to is the subarachnoid space. The other thing that occurs in trauma like this is you can get a subdural. So the dura is the membrane that covers the whole brain and also right down your spinal canal. And it's a very thin membrane that looks like very thin leather. And in that space between the brain and the dura can be a lot of veins that go towards a central vein called the sagittal sinus. And if those tear, you have a venous hemorrhage which is not arterial, so it's not quick, but that can develop into a subdural as well. If you tear a portion of your brain as well, and you get a little arterial bleeds, that could create a much faster subdural hematoma. And so when you look at the pathology, the autopsy of his brain, you're looking at a subarachnoid hemorrhage, you're looking at a subdural hemorrhage, neither one of them which was huge or would have required surgery, as well as the contusions that I described in his frontal poles, in his temporal poles, and then the original bang, which was in the occipital area. These are all findings that you would see on a CT scan and an MRI scan without requiring an autopsy if he had made it to the emergency room.
I want to take a step back. At the beginning, you said that this laceration on the back of his head was caused by a fall. Could this be caused by a fall landing on hard ground?
Yes. I mean, like I said, it's a classic blunt trauma laceration.
Do you have an opinion to a reasonable degree of medical certainty whether this injury, the laceration and the basal fracture, was caused by Mr. O'Keefe falling backwards on the ground?
My opinion is that that's what caused his whole injury.
The pattern of the laceration, do you have an opinion whether that is consistent with hitting the cold, hard ground?
Objection, Your Honor. Can we have sidebar on that, please?
So I'm sustaining the objection, so no sidebar.
Your Honor.
Do you have an opinion, doctor, about whether that laceration on the back of his head was caused by a particular movement?
Well, the only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain and to his base of his skull.
Would that type of laceration require Mr. O'Keefe to have hit a line type or ridge type object?
A ridge type of object?
Yes.
No, I mean, like I said, the tearing of the skin in that fashion, you could look it up, would be just a classic blunt trauma injury.
Is there anything about that injury that would suggest to you it had to have been something sharp or ridge-like to cause?
Objection, Your Honor. Again, request kindly a sidebar on this.
All right, we'll come to that.
Okay, Hank, I see what you're doing now. I had to put both ears in because this surgeon here is very articulate and he know he's a real expert. Okay, this man is doing 4-5 brain surgeries a day. Okay, he's doing 15 of them a week. Okay, I don't know, I'm exaggerating, y'all. I'm exaggerating, but get my point. My point is this man know what the hell he's talking about, and Brennan is out here trying to get what has got him to say that basically John O'Keefe fell backwards. And that caused his skull injury. And the laceration could have come just from the fall itself, right? He's trying to make it seem like he's trying to get across to the jury that he didn't fall and hit his head on something like a step, or nobody picked up something and smashed it in the back of his head in order for him to get that laceration. But at the end of the day, the only thing that this man is testifying to is that John O'Keefe fell backwards on his head. Okay. Yes, D Wood. That's where I was finna go. My theory is John O'Keefe fell backwards on his head, and that's because somebody hit him with a left hook inside the house. Okay. They hit him with the left hook because they was jumping him, right? I believe they was putting paws on him. Okay. And it got to the point where somebody hit that last and John O'Keefe fell and he hit the floor. All right. We don't know what the floor used to look like down in that basement. Okay, they say they pulled it up. I don't know if it was carpet down there on top of cement. If it was just cement and they threw some what they call it, some flank vinyl on the floor. I don't know what they did, but I do know John O'Keefe hit his head and he hit it falling backwards. What they have not proven is how he hit the ground. Did he hit the ground because Karen hit him with the car and he fell in the grass on the frozen grass and bust his head? Or was he hit with the left hook? I don't know. Let's get over here to the trial. So as y'all know, Hughes is now on the stand. Hughes, victims of domestic violence often stay with their abusers as they feel there are no better option. Hughes is testifying.
So as we were discussing, Dr. Wolf, you said this is a classic fall backwards. Is there anything about the pattern of that laceration that would suggest that there was a ridge or a line type edge that caused that wound?
Not necessarily.
And have you seen, in your experience, similar types of lacerations and breaks caused by falling on hard ground?
Yes, you can see that both in the occipital region. You can see it if patients fall on the forehead. The skin tears, they're still bridging, and then they get bruises.
Some of your work was in Minnesota?
Correct.
Was it a colder part of Minnesota?
Very cold part of Minnesota. It's Minneapolis.
I'm sorry. Did you often see these type of injuries there?
Yes. I mean, we took care of a trauma center, Hennepin County. Very frequently, patients that are drunk fall down on ice sidewalks and could develop, lacerations in their head, epidurals, which are blood clots above the dura because they fracture a bone in the temporal area and they can get a bleed from a fractured artery. And it happens when people are shoveling snow and have a heart attack and fall backwards. So there are various ways that people fall, resulting in head injuries and lacerations to their forehead or to different areas of their head.
Can somebody suffer this type of injury simply by falling backwards?
Absolutely.
You had taken us through the process of falling backwards and then talked about what happens to the brain. Can I ask you a couple detailed questions about that?
Sure.
When you explained that the brain upon impact then shifts forward and hits the front of the skull, is there a medical term for that process?
Well, the medical term is a coup counter coup injury. So the coup is when you first hit. In this case, it was the back of the head, as summarized by the laceration in the back of the head, and the contusions that the pathologist and the ME found in the back of the brain. And then the brain shifts forward, and as it's traveling at a certain velocity, because it's thrust forward on the floor of the base of the skull, it's getting bumped. And it's getting, again, you can think of it as a hammer hitting a thumb. It's getting black and blue in the areas that are sharpest.
Are there symptoms that result of the process coup counter coup?
This is clinically, it varies. I mean, you can go from anywhere from a simple concussion where you sort of are unaware of what happened, but you're still awake, you're confused, all the way to, ultimately being in a coma.
Can this type of injury, the coup counter coup, and what you see in the review of your files, could this type of injury happen from an attack by a weapon, like a bat or a hammer?
Well, he did not have a depressed skull fracture. So any focal hit like that would more likely than not have caused a depressed skull fracture. Blunt trauma, the way he had, the assumption, would cause the coup counter coup without a depressed skull fracture.
When the coup counter coup process happens with the skull fracture, does anything happen to the front of the skull?
Well, you're asking me, does the rest, I mean, the forces, depending on how hard they are, can generate fracture lines all the way to the anterior fossa. So you can have fractures along the lateral temporal area. You can have fractures along the orbital roof. The orbital roof is very thin. And so those forces can go all the way to that area.
Did you see any sign of orbital fractures in Mr. O'Keefe?
Yes, he had both the ME and the pictures taken, and the neuropathologist mentioned fractures of the orbital roof.
Do you have an opinion to a reasonable degree of medical certainty how those fractures occurred?
From the trauma.
Could you just explain a little bit how that would happen?
Well, as he fell backwards and he struck his head, it was clearly at a very high speed generated by the gravity. The bone, depending on the quality of his bone, the density, then generated forces. There's a certain amount of lateral give, and then you get a linear force going forward. It drives all the way up the clivus and forward into the anterior fossa where his orbital roofs lay. And this is why people like this get what they call raccoon's eyes.
Do you have an opinion whether the brain itself could have caused the orbital fractures?
No. The brain is a soft substance. You could literally put your finger through the brain. We often operate on people fully awake. The brain couldn't possibly cause a fracture. The fracture was caused by the forces generated through that clivus, that middle bone in the middle of his base of the skull.
Do you have an opinion to a reasonable degree of medical certainty whether or not the brain in any way could have caused these orbital fractures?
The answer is absolutely not.
In your study of the records and photographs, and in your experience treating these types of injuries, do you have an opinion to a reasonable degree of medical certainty whether or not a person would remain conscious or would be immediately unconscious after the impact of the ground?
Well, it's impossible to know whether he became immediately unconscious, but his injuries were very substantial. And it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
What does functional activities mean?
The ability to, get himself up and about would be one of the functional activities. The ability to call for help would be a very significant cortical function. And that's why I was talking about, that there's a variation on the theme from a simple concussion to a severe concussion like this.
If a person does not have functional abilities because they are rendered unconscious, does their body, could it still move?
Yes, this is the interesting thing about our brain. So the cortex, which is the top portion of your brain, can get separated from your brainstem functionally. And what happens then is that your body is not acting autonomically, meaning vegetative. So why does that happen? We think it's because as we were a caveman, and if a caveman became unconscious, as an animal came up to eat it, the animal would touch it. Well, you have these automatic movements. One of them is called decorticating, which is where you draw your arms like this and you throw your feet out. And then a worse neurological situation is when you decerebrate. Now you push your arms out along with your legs. And that would scare off an animal. So we think that over time, genetically, this is what happened to our brains in order to create these. But those kind of movements are not thought processes. In other words, your brain is not telling you, oh, you have pain, go ahead and decorticate or decerebrate. It's an automatic movement in response to pain.
I want you to take us back now to after the fall. Would Mr. O'Keefe, in your study and opinion, have died immediately?
No.
Can you share?
I don't.
I'm sorry.
Yes, I'll tell it. There is very few things that you head injury where you would die, quote, immediately. So if I took a knife and stabbed you in the back of your neck right below your skull and I drove it through your brainstem, you would probably die immediately. If I shot you below your ear and went through and through below your ear and shot through your brainstem, you would die immediately. But traumatic head injuries, you would not die immediately. It's a process. And it's a process of a combination of things. Brain swelling, which takes a while to develop. Decreased blood flow to your brain because you're getting swelling. And ultimately, death of the brainstem that controls your heart and your breathing. And so this is why there is a whole big issue about brain death. When is someone brain dead? Because it's not instant and it can take a long time to be conceived. In these injuries that are very severe that we took care of, there was a high mortality rate. In the linear skull fractures, it was about 67%. But it took time for them to die. It could take days to weeks to months. And also, these people got to shock trauma. So it was a while, whether it was hours, before they were even starting to be taken care of. And yet they weren't dead yet. That's why I don't think it was immediate.
Was there any other observations you made about Mr. O'Keefe or his body that support your opinion that he didn't die immediately?
Well, the medical examiner took pictures of his periorbital area and diagnosed raccoon's eyes. So raccoon's eyes occur because there's leakage through the orbital fractures into the periorbital space. Normally, it takes about 24 to 48 hours to develop. It has been noted as early as 1 to 3 hours, which would make it not immediate.
Could we please have Exhibit 14? Dr. Wolf, could you share with us what you see here in this picture?
So right here, you can see the black and blue that sort of configures if he had his eyes open, like what we describe as raccoon's eyes, right? And that's not caused by direct trauma to his eyelids. It's caused by what I described as the basilar skull fracture, which went to the anterior fossa, which is right over the orbit here, inside with leakage of blood products into that periorbital area.
You mentioned that starts or takes at least 1 to 3 hours to begin.
Minimally, yes.
You take that down, please. If Mr. O'Keefe had been brought to a trauma center or emergency room, what would the process be in your experience?
Well, he would have been intubated if he wasn't intubated in the field. One of the first things you need to do in a head injury is control the airway. Why? 2 reasons. One, you want to have enough oxygen going to the brain to feed it. And 2, you want to keep your carbon dioxide down because that causes increased intracranial pressure if it elevates. So you want to constrict the blood vessels a little bit. Then he would have had a CT scan immediately in order to assess whether he has a surgical head injury, meaning he needs to go to the operating room to evacuate something or not. During that process, he's obviously going to be getting medication to decrease the brain swelling. And from there, you make decisions based on his neurological function and what you're, capable of doing to, spare the brain from the rest of the injuries that will result. One of the things that occurs with contusions is a great medical term is they can blossom, which means they can get bigger. And if they get bigger, they might require surgical intervention to decrease the pressure as well as the volume of the blood that's destroying brain. And so you do serial CT scans in these patients over time, anywhere from every 6 to 12 hours to on a daily basis, depending on what the case by case, production of blossoming is occurring.
You mentioned that about 2/3 of your patients who suffer this injury pass.
Correct. What we saw is that in the patients that suffered linear clavicle fractures, 2/3 of them ultimately went on to die, and 1/3 lived.
Is there commonality on how they pass?
One of the common reasons they passed is if they trapped a major vessel in one of the fractures, they would get a significant brainstem infarct, meaning a stroke, meaning lack of blood flow to a very significant portion of their brainstem. And so that was one of the causes of death that ultimately we understood. And then the others died from the increased intracranial pressure that drove the brainstem down through the foramen magnum.
Did you review any materials that talked about or identified Mr. O'Keefe's body temperature when he was treated?
As I recall, his core temperature was 80 when he was found.
Is that significant in the process and development of his injury from the moment he fell and hit his head until his ultimate passing?
Well, hypothermia, if you define hypothermia, it starts at 95 degrees. Your core temperature is usually about 98, 98.6. 95 is very mild hypothermia. When you get to 82 degrees, you're in severe hypothermia. What happens when you're hypothermic, and I'm a neurosurgeon, but I can tell you that you get into multiple organ failure. Your heart starts to have problems. It can have arrhythmias. You're not breathing. And ultimately, at hypothermia, you also become unconscious and go into a coma-like state. Below 80 degrees, you're probably going to die. So all I can tell you, it wasn't helpful that he had a significant head injury and that he was then found hypothermic.
Is it uncommon in your experience for people that suffer this injury to pass within 5 hours?
Well, none of the patients we treated died within 5 hours, but it also didn't mean that we didn't realize that they were going to be in a potentially vegetative state. When someone's hypothermic, you have to warm them up in order to establish a clinical status, meaning you can't declare someone dead with a temperature of 80. You have to warm them up slowly, appropriately, and then reevaluate where they are clinically.
I've asked you questions about whether you had an opinion about Mr. O'Keefe and when he died. I want to ask it in the form of a formal opinion. Do you have an opinion to a reasonable degree of medical certainty whether Mr. O'Keefe died immediately or within 15 minutes?
No, I don't think he died immediately. Neither the hypothermia nor this kind of head injury would kill you immediately in any clinical experience I have.
Dr. Wolf, thank you.
All right.
Let me have a moment, Your Honor.
Sure.
Thank you. May I, Your Honor?
Yes.
Morning, Doctor. I don't think we've had the pleasure of meeting. Welcome.
Thank you.
Sir, can you just describe, you started to do it a little bit on direct, a typical day for you?
I wake up at 4:15 in the morning. I go to my center. I set up patients with frames for their either radiosurgical procedures or stereotactic craniotomies. I go home. I make cappuccino for my wife at 6 o'clock in the morning. And then I get back to work at 6:30 and move on. I have patients that I'm operating on, and I have patients that I'm seeing through the day.
What type of patients and what type of work, just in a typical day? What are you doing? What type of patients and what do you do?
It varies. I mean, I see patients with brain tumors. I see patients with hydrocephalus, which is water in their brain. I see pediatric brain tumors. I see subacute and chronic subdural hematomas, post-traumatic. I see patients with strokes that are being misdiagnosed. I see patients with cancer, metastatic disease. I used to see patients with cervical problems. I stopped doing that 2 years ago. I mean, I don't know what else you want me to tell you.
No, that's great. And is that typical day, typical of the type of days you've had for the past month, past few years? Is it generally, without specifics, is it generally?
Correct.
So none of your typical days, none of the past typical months have involved forensic pathology, have they? You haven't acted as a forensic pathologist in.
I am, if you could have asked that question, very straightforward. I am not a forensic pathologist. I'm a brain surgeon.
Right. And you don't perform autopsies, correct, sir? You're a brain surgeon.
Correct. In other words, I see more brains than the forensic pathologist.
Right. And is it correct to say that the brains that you see are of living people?
Correct.
Okay. So what I'd like to do is to go to a different part of the head than was discussed, but sticking with the decedent.
Excuse me, I didn't hear the last word.
I'm sorry, with the topic is going to be Mr. O'Keefe, the decedent in this matter, sir. You testified about raccoon eyes. The medical term for that, sir, is ecchymosis, right?
Correct.
And ecchymosis, raccoon eyes, does not cause a laceration to form on an eyelid, does it?
No.
Are you aware that Mr. O'Keefe had a laceration to the outside area of his right upper eyelid?
I am aware that the ME described that. Yes, sir.
Now, could, Your Honor, I'm going to, with Your Honor's permission, ask to publish what is already in evidence in a moment.
Okay.
Mr. Wolk,
What exhibit number, Mr. Alessi?
we're going to, 165, Your Honor.
Okay, go right ahead.
Thank you. Dr. Wolf, have you seen this photo depiction before today?
I believe I have.
Is it correct that that injury on the upper right eyelid is caused by the application of force directly to that area of the front of the head, again, namely the upper eyelid?
That's possible, yes.
Is it more than possible? Is it probable that that injury was caused by the application of force directly to that area of the front of his head?
Well, an easy answer to that would be is that that's not part of the periorbital ecchymosis.
Thank you, sir. That was exactly going to be my next question. This injury is unrelated to any of what you've been describing, the fall backwards, the force transfer inside the skull, the, as you described it, the dura, the cerebral spinal fluid, all of that dynamic that you so ably described on your direct examination. This injury has nothing to do with that, correct?
Correct.
Thank you for answering my questions, Dr. Wolf. A pleasure again. No more questions at this time, Your Honor.
Any brief follow-up on that?
No, thank you.
All right, Dr. Wolf, you're all set, so you can get out of here.
Thank you very much.
All right. Mr. Brennan?
May we have a moment to inquire of our next witness?
Sure. And when I see counsel outside our jurors, feel free to stand up and stretch.
Yeah. Yeah, for real. He drinking that water like, but he is a surgeon, so he might be used to standing for long periods of time. But I'm pretty sure he taking very, very little sips of water while he's doing surgery, right? You don't want any of that to really get into the field. But I watch a lot of Grey's Anatomy. Okay, a lot of it. Okay, look, I watch a little Resident. But Grey's Anatomy is where I got my surgeon degree from. Okay, it was where I did my internship and my residency. So don't play with me, right?
So jurors, you may realize that that went quicker than we thought. So we are ahead of schedule. So why don't we take that morning break that we can take? So we'll take a 15 or 20 minutes.
Child, y'all don't need
All rise
15
for
to
the
20
court,
minutes to
please.
do a goddamn
Jurors, look.
thing. This woman. Lord have mercy. Let me get us a. Y'all know I'm on here reading my damn heart out. Y'all know I'm on here reading my heart out because I done been on here reading and ain't nobody said shit. I gotta remember to hit the unmute button. Jeez. God. I'm gonna start with testimony, okay? I'm gonna start with testimony because yeah. Kid Cudi ain't testifying today. All right. Mr. Gannon gets back on the stand. Let's continue with the items you seized. GX215. What is this? High heels and sex items in the master closet. What's this? 3 cell phones found in one of the boots. Display the Gucci bag for the jury. Pull up the exhibit and stipulation. Zoom in on paragraph 5. A white plastic bottle contained liquid residue of meth and liquid MDMA. These pills were found with the Tesla imprint on them. These had the active ingredient in Xanax. This $100 bill had residue of cocaine on it. Mr. Cannon, what's this? A dark wooden box with the word puffy on top. How do you know that this is the Astroglide and baby oil that you seized? How many bottles of each? 31 bottles of Astroglide, 25 bottles of baby oil. Any other cell phones found? Yes. Was a gun found in the suitcase? Yes, a 45. Hold up the bullets for the jury. No further questions. They went across. Day of the search, you knew that Mr. Combs was leaving the country with his twin daughters. They had a sidebar. In planning the search, you knew that none of the targets of the investigation would be there. Objection overruled. The plan was to have him not there, but we had contingencies. What type of vehicles did you use? He said he used the armored vehicle and a boat. Come by land and sea. It's a common practice. 80 or 90 agents, but not all at the same time. You found 6 people and kept them in handcuffs for an hour. No, ma'am. There was one individual who wasn't happy with us and wasn't cooperating, so we kept him in handcuffs longer because he wasn't happy with the cuffs. There was a music studio in the guest home, right? Do you recognize this? Yes, it's the studio. Move to admit. The gun was wrapped in a towel. It didn't look like how you displayed it to the jury yesterday, right? Yes, ma'am. Did you find any photos of Mr. Combs with these firearms? We did not. Do you agree that the handgun's metal is easier to get fingerprints than maybe another type of device? Can't say if it's easier, but it can be done. Can you get prints off a gun easier when it's inside? I think so. At HSI, do you have Mr. Combs? You have Mr. Combs' DNA, right? I don't know. When he was arrested, the government took his DNA swab, right? I don't know. Hold up the Gucci bag. The drugs were in this bag and in the puffy box, right? Yes. Your Honor, I'm going to introduce a sealed exhibit. So basically, they didn't show him a picture of somebody. They didn't cut the screens off and said, look at this. He says, please don't say the names of the people in this photograph. Other than my client, don't talk about it. Can maybe confer with counsel. The attorneys talk. We may take the sealed exhibit down. You live in Florida. Don't many people have guns in their homes? Objection. Rephrase. Do you have guns in your home? Yes. No further questions. Redirect. Next witness. Redirect was a no. And they called the next witness, who was Dr. Hughes. Dr. Hughes says he's a clinic. He's a clinical and forensic psychology. He's into clinical and forensic psychology, and he treated people who were in World War II, and it was such an honor for him. He's asked how many times he testified in court. He says 60 to 65 times. He goes over the different places that he's testified at. All right. They offered him as an expert, and he was not objected to. What do you anticipate covering? Why victims stay? Memory. Have you been retained by the government? Yes. What is your hourly rate? $600, $6,000 for a day in court. And this is where I told y'all that my daggone job description is wrong, because I need to be a clinical and forensic psychologist. Okay. Moving on. Why do victims stay? There are psychological bonds and psychological consequences of abuse. What are the levels of fear? It ranges from physical violence to butterflies. Violence doesn't have to happen all the time. What is psychological violence? Intimidation, throwing things, telling you what you can do and where you can go. Objection. Hold on. I'm going to strike that last answer. What can be the role of sexual abuse? It puts the victim in a significant psychological fear. Why does it prevent leaving? Shame, degradation. They don't want to think about it. What is emotional abuse? Putting down our partner, basically making them feel like a piece of crap. What about financial dependency? The abuser controls housing and transportation, taking away her laptop. Objection sustained. Are you familiar with love bombing? That honeymoon phase when the abuser showers her with gifts and affection to get her back. Does the attempt to leave happen over time? Yes, it takes multiple attempts. Which is the most common coping mechanism? Trying to work it out because of the trauma bond. You don't want to lose your partner. Personal coping mechanism. How does placating and appeasing work? We're trying to avoid abuse. What is minimization? The victim says maybe they had a bad day at work, maybe they were intoxicated. It's a way to stay in a relationship, but it increases their risk. It's not a long-term strategy. It gets from one assaultive episode to the next. What about power relation? A person can have power as principal of a school. The victim asks, who is going to believe me? When does the victim finally speak? In a safe environment or after psychological help? What type of language do victims use when they first speak out of it? They minimalize. They are piecemeal. They remember the chipping paint on the ceiling, the smell of alcohol on the perpetrator's breath. Sidebar. It will, okay. Your client, okay, wait a minute. Sidebar, then cross-examination. Your clients, you observe them closely, their cognitive style. Yes. People don't fit into boxes, right? There are categories, but you have to listen to particular individuals, right? I'm not divorced from my training. That's where we left off at. So yeah. There we go. There we go. But we're gonna jump on over here to also see what was talked about over here on NBC News. All right. So over here, they're talking about victims of domestic violence often stay with their abusers as they feel like there are no better options. These victims who stay in these toxic relationships tend to fall into three categories because they feel trapped, still feel a bond to their abuser, and believe that the act of leaving the relationship is far too complex to achieve. Hugh's testimony could be key to the prosecution efforts to fight the defense's narrative that women such as Combs' former girlfriend, Cassie, could have left their 11-year relationship. Domestic violence victims fall prey to psychological, sexual, and emotional abuse, as well as financial dependence, making it all the harder for them to fight back or cut themselves loose, Hughes said. Victims suffering from psychological abuse walk on eggshells and focus on how to stay safe in the moment rather than a big picture solution, such as exiting a toxic relationship. Sexual abuse can bring shame and humiliation, which leads victims to worry about keeping this harm private, which again keeps them from seeking an ultimate end to a bad relationship. The price of emotional abuse leads victims to simply believe they're not worthy of anything more, thus draining them of the energy or motivation to get help. Hughes describes financial dependency as very important, as it deprives the victim of the material resources needed to leave an abusive relationship. If you don't have money, you are left with a feeling of where am I going to go? Child. Kim says she don't like homeboy. Kim says she don't like Hughes. She ain't liked Hughes since the Johnny Depp defamation. She ain't like him. Diddy's bathroom mirror was scrawled with handwritten messages, hyping up the once beloved hip hop star. A photo from a federal raid on his Miami Beach house mansion. Wow, you're a legend. You're an icon, Puff Daddy. Upward motion can be seen written on the mirror in a photograph from March 25, 2024 raid. Whether Diddy Sean Combs wrote the inspirational messages, which included "What do you want?" is unclear. Child, that man is crazy. She know you. I need me a bottle of water, y'all. I'm about to get out of there. All right, I'm about to go grab a bottle of water from the store. One second, y'all. All right. We all caught up. So, how did y'all feel about the redirect? Because I missed the cross of the neurosurgeon guy, y'all. So we're gonna have to go back and listen to it on the next time we on the break and everybody on the break. We're gonna have to go back and listen to it because I don't know. I didn't really get to hear the cross. So give me up to speed. Okay, so D Wood, he really just said that when he testified, he basically is D Wood still in here before I break this down? Before I say it, y'all gotta keep me honest too, okay? Because what I heard was John O'Keefe injury came from a fall. He fell to the back of his head. He fell and hit the back of his head. And when he hit the back of his head, he got a laceration. The laceration could have been caused from a fall on a regular surface. It didn't have to be a surface that had like a ledge on it or ridge on it, or if somebody like hit him with something. He's saying that he could have just fallen and gotten a laceration from the fall. He also said that the skull cracked, fluid leaked, and the brain shifted and swished around, and the excess fluid went to the front of his eyes and kind of sat there or something, or whatever it is. Extra fluid went to the front of his eyes and caused the raccoon eyes or darkening of the eyes. That's what I got from Direct. Now, I missed Cross, so I don't know what happened on Cross. I missed stand up.
We're back in session. You may be seated.
All right, may we have Ms. Hanley, please?
And ma'am, I'll remind you, you're still under oath and to keep your voice up. Thank you.
Good afternoon. All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. And ma'am, if you could just please introduce yourself to the jury again, spelling your last name for the record.
Sure. I'm Christina Hanley. Hanley is spelled Hanley.
And Ms. Hanley, given the break, if I could just ask you a few questions just to reorient as far as the items that we were speaking about yesterday in your testimony. First, starting with the items of glass that you analyzed in this case. The first of those items was an item 3-2, is that correct?
That's correct.
And if you could, please describe for the jury, or please provide the jury with the description for that item that you received.
Sure. So item 3-2 was a clear glass cup with broken irregular edges. And there was some dirt debris material that was noted on the exterior and interior surfaces.
Your Honor, may I approach?
Yes. Did you show counsel? All right, thank you.
I gave Mr. Jackson my copy. Yes, thank you. Showing you a photograph, Ms. Hanley, do you recognize that?
Yes, I do.
And what do you recognize that?
So this is a photograph that I took. It's item 3-2, but it's also, I would have to double check on my notes, but I believe it has item 7-12, one of the pieces that I'm holding that's showing a physical match between those two items.
Your Honor, call both the seat to introduce in the minutes of the next exhibit.
No objection.
Okay.
Exhibit 195.
And Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 9490.
Ms. Hanley, what's up on the screen, is that the photograph that I just presented to you?
Yes, it is.
And if you could, please describe for the jury what we're looking at here.
So that is a photograph that I took upon examination. It is the clear glass cup item 3-2. And I'm holding another piece, which again, I believe it's one of the pieces from item 7-12. I would need to confirm in my file, but I'm showing that one of the pieces physically fits with item 3-2.
Thank you, ma'am. Ms. Gilman, you can take that down. May I approach again, Your Honor?
Yes.
Showing you two other photographs. If you could just look at those, look up when you're finished. Did you recognize those?
Yes, I do.
And what do you recognize those as?
So these are photographs that I took of item 7-12.
Your Honor, the Commonwealth will seek to introduce and admit as the next exhibit A and B.
Is there any objection?
No objection.
Thank you.
Exhibits 196A and 196B.
And Ms. Hanley, if you could just remind the jury as far as the physical description that you received in regard to item 7-12.
Sure. So item 7-12 consisted of some clear plastic pieces as well as 9 pieces of glass with broken irregular edges.
And may I publish, Your Honor?
Yes.
And Ms. Gilman, if I could have first photograph 9476. And if you can enlarge that just a bit, Ms. Gilman. And Ms. Hanley, what are we looking at in this photograph?
So this is the photo that I took of item 7-12 as I received it. So there's the several pieces of clear glass with broken irregular edges.
And Ms. Gilman, if I could have 9477. And if you can enlarge that just a bit. And again, Ms. Hanley, what are we looking at in this photograph?
Those are the same pieces of glass as in the previous photo, just a little bit more up close of the clear glass that was recovered and is item 7-12.
Thank you. Ms. Gilman, you can take that down. Now, Ms. Hanley, as far as a comparative analysis between items in 3-2, the glass, and 7-12 regarding the glass pieces, what, if any, conclusions did you make in reference to your comparison between those two items?
Sure. So upon comparing those items, I did note that 6 of the 9 pieces of clear apparent glass had a physical match to item 3-2, the clear glass cup.
And if you could just remind the jury as far as a physical match, what does that mean?
So a physical match is basically if an item breaks and those items have broken irregular edges, if those pieces come back together like a jigsaw fit, then it's a physical match and they were at one time together as one larger unit.
Now, as far as each of those items within 7-12 had a letter associated with them, correct?
Yes.
And do you recall which of the 6 were a physical match for item 3-2, the glass?
I would just need to refer to my notes for the exact letters.
Sure, you can take your report out.
The 6 pieces of glass from item 712 that physically fit to item 3-2 were A, B, C, D, F, and K.
May I approach, Your Honor?
Yes.
Well, let me ask you this first. I'm sorry. So, Ms. Hanley, during the course of this physical match analysis that you're conducting, are you memorializing that process with photographs as well?
Yes, I am.
May I approach, Your Honor?
Yes.
And I'm presenting you with 4 photographs. If you could review those and look up when you finish. And do you recognize those, ma'am?
Yes, I do.
And what do you recognize those?
Those are photographs that I took upon my examination of items 712 and item 3-2.
Your Honor, the combo is introduced and admitted as the next exhibits, A through D.
No objection.
Thank you.
Exhibits 197A through D.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9502, please. And Ms. Hanley, what's up on the screen? Can you please describe for the jury what we're looking at in this photograph?
So this is one of the photos that I took of one of the breaks that physically fit together between item 3-2 and item 7-12.
And Ms. Gilman, if I could have 9514. And again, Ms. Hanley, can you please describe for the jury what we're looking at in this photograph?
Sure. So this is a photo that I took when I was doing my comparison of item 3-2 and several pieces from item 7-12.
Now, as far as the individual pieces had sort of little white stickers or labels affixed to them, is that correct?
Yes.
Is that something that you did, or is that something that when the items were provided to you was already done?
So item 7-12, I received those pieces with the labels already on them.
And again, those items, especially 7-12, had been with mixed veneer in your unit prior to coming to your table or your station, correct?
Yes.
Ms. Gilman, if I could have 9518. Again, Ms. Hanley, what are we looking at here?
So this is another photograph that I took of the physical match. It's just another view of the items together of item 3-2 and several pieces from item 7-12.
And lastly, for this batch, Ms. Gilman, if I could have 9520. And again, Ms. Hanley, what are we looking at here?
So this is another picture that I took of the items just slightly rotated of item 3-2 with a physical fit to several items or several pieces from item 7-12.
Ms. Hanley, is there a laser pointer on the desk in front of you?
Yes.
If you could, preferably using this screen just so it's visible for the jury, could you delineate where you see in this photograph item 3-2 and where you see the items associated with item 7-12?
So this right here is item 3-2, and these pieces up here are several pieces from 7-12.
Thank you. Ms. Gilman, you can take that down. Now, the other 2 items that you analyzed or examined in this part of your physical match analysis were items 3-3 and 7-14, correct?
That's correct.
And turning your attention specifically to item 3-3, if you could just remind the jury as far as the physical description of that item that was provided to you.
Sure. So item 3-3 was 5 pieces of clear glass with broken irregular edges that were recovered from the bumper of the vehicle.
May I approach again, Your Honor?
Yes.
Single photograph, do you recognize that?
Yes, I do.
And what do you recognize that?
That is a photo that I took of item 3-3.
Your Honor, Commonwealth seek to introduce in a minute the next exhibit.
No objection, Mr. Jackson?
No objection, Your Honor.
All right.
Exhibit 198.
And may I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9446, please. And Ms. Hanley, in addition to the 5 pieces of glass associated with item 3-3, what else is depicted in this photograph?
This is a photo of the 5 total pieces that are from item 3-3.
And in addition to that, is there a ruler depicted in this photograph as well?
Yes, there is.
And what is the purpose of that ruler in the photograph?
It's there just as a scale.
Thank you, Ms. Gilman. You can take that one down. And Ms. Hanley, the last of those items, 7-14, if you could just remind the jury as far as what was the physical description that was provided to you in reference to item 7-14.
Sure. So item 7-14 was a clear piece of glass with broken irregular edges that was recovered from the road.
May I approach again, Your Honor?
Yes.
Again, Ms. Hanley, just showing you a single photograph. Do you recognize that?
Yes, I do.
And what do you recognize?
This is a photo that I took of item 7-14.
Your Honor, Commonwealth seek to introduce the next exhibit. No objection.
All right.
Exhibit 199.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have 9471, please.
So
And again-
the two screens don't match.
No.
Thank you.
Thank you, Your Honor. Ms. Hanley, again, if you could just describe for the jury what is depicted in the photograph up on the screen.
This is the photo that I took of item 7-14.
Thank you. Ms. Gilman, you can take that down. So, Ms. Hanley, in addition to the physical match analysis that you did between item 3-2, the cup, and 6 of the pieces that you found to be a physical match from item 7-12, did you also compare pieces from item 3-2, 7-12, and 7-14?
Yes, I did.
And what did you conclude in your physical match analysis of those items together?
So upon examining and comparing item 3-2, 7-12, and 7-14, I had concluded that 6 of the 9 pieces of glass from 7-12 physically fit with item 3-2, and the remaining 3 of the 9 from 7-12 did not have a physical fit to item 3-2. I also compared item 3-2 and 7-12 to 7-14, but there was no physical match to item 7-14.
Now, in addition to that, did you also do a physical match analysis between item 3-2, the drinking glass, 7-12, pieces found from the roadway, and certain pieces from 3-3 from the bumper of the vehicle.
Yes, I did.
And what did you conclude based on that physical match analysis between those items?
So upon examining and comparing those items, so there were 5 total pieces of glass from item 3-3. I used 2 of those pieces for physical match comparison to the items recovered from the road. Upon my examination, I did not, there was no physical match between those 2 pieces from item 3-3 to any of the pieces recovered from the road. So that included items 3-2, 7-12, and 7-14.
Now, as far as the 2 pieces that you had selected from item 3-3, do you recall which of those 2 lettered pieces you chose for your comparative analysis?
Yes.
And which were they?
They were pieces A and B.
And if I could ask, why pieces A and B versus other pieces?
So A and B were used for physical match. The remaining 3 of the 5 were not used for physical match comparison due to their size and condition.
Now, those same 2 pieces from item 3-3, pieces A and B, did you then do a physical match analysis between that and 7-14?
I did.
And what did you conclude from that analysis?
I concluded that there was no physical match between the 2 pieces from item 3-3 to item 7-14.
Now, did you also do a physical match analysis between piece E from item 3-3 from the bumper?
I did not. No, not a physical match examination.
Did you do any comparative analysis between a piece of glass E from 3-3 from the bumper and item 7-14?
Yes, I did.
And what did you conclude from that analysis?
So I selected piece E for further examination. I did microscopic examination as well as instrumental analysis, and I did the same microscopic and instrumental analysis to 7-14, and I compared the data, and I came to the conclusion that the piece that I sampled from item 3-3, piece E, was found to be consistent in physical and instrumental properties to the sample that I took from item 7-14.
If you could, Ms. Hanley, could you please explain to the jury when you say instrumental analysis, what is that? What does that consist of?
So the instrumental analysis that I conducted was on the GRIM instrument, which measures the refractive index of the samples. So after I had ran my samples for both item 3-3 and 7-14, I compared the data to determine whether they were consistent or not consistent.
And so when you say that something is consistent in instrumental properties, what does that mean?
So in this instance, they had consistent refractive indices.
Now, in addition to that comparative analysis for the glass items, what other additional examinations did you perform in this case?
Sorry, could you say that again?
In addition to items 3-2, 3-3, 7-12, and 7-14, what other items did you look at in this case?
So I also examined item 3-1 and item 7-18.18.
And what was the description provided to you in reference to item 3-1?
3-1 was a taillight, and there were also some other plastic pieces as well.
And taillight from the same vehicle as the glass from the bumper, correct?
Yes.
May I approach, Your Honor?
Yes.
You have another single photograph. Do you recognize that?
Yes, I do.
And what do you recognize that?
This is the photo that I took of item 3-1.
Your Honor, the Commonwealth will seek to introduce in the minutes.
No objection.
Thank you.
200.
May I publish, Your Honor?
Yes.
Ms. Gilman, if I could have photograph 9394. And Ms. Hanley, do you recognize what's up on the screen as Exhibit 200?
Yes, I do.
And what do you recognize it to be?
This is the photo that I took of item 3-1.
And what's contained in here, is that a fair and accurate portrayal of what the item 3-1, the taillight housing, looked like when you received it?
Yes.
Now, as far as, and we'll get to this more a bit in a moment, but as far as any sort of comparative analysis that you did with any other item, what part of this taillight housing were you comparing to that other item?
So there were clear and red plastic portions of the taillight that appeared to be broken. So I sampled portions of the clear plastic as well as the red plastic on the taillight.
And just for clarity purposes, if you could with the pointer, as far as which of these pieces up on the screen were you sampling the clear and or the red plastic from?
So the red plastic that I sampled was from this area. It's a little hard to tell from here. I think I'd have to refer to my photo in my notes, but I think there were a couple of different areas that had clear broken plastic. I think this might have been one of the areas that was broken that I sampled.
And just for my purposes, really what I'm asking, Ms. Hanley, is the clear plastic that you used from item 3-1 was from the housing unit itself, the large piece, correct?
Yes.
Okay. Ms. Gilman, you can take that down. Now, the other item that you were comparing this to was item 7-18.18. Is that correct?
Yes, that's correct.
And what was provided to you as the description of that item 7-18.18?
7-18.18 was debris that was collected from 2 pieces of clothing from the victim.
And specifically, that would be 7-17, an orange T-shirt. Is that correct?
I believe that is correct, yeah.
Okay, as well as 7-18, a gray long sleeve shirt. Is that correct?
Yes.
And when you say that item 7-18.18 contained debris, what did that debris consist of?
So the debris consisted of one clear piece of plastic, as well as several pieces of red plastic, among some other trace material.
Now, were there measurements taken of those items within the debris, specifically the clear plastic and the red plastic?
Yes.
And what were those measured to be?
I would just need to refer to my report for that.
Okay, go ahead.
Thank you. So the clear piece of plastic in 7-18.18, it measured approximately 1/8 of an inch by 1/16 of an inch. And then I measured the largest and the smallest of the red plastic pieces. And the largest piece of red plastic measured approximately 1/16 of an inch by less than 1/16 of an inch. And the smallest piece among those measured approximately less than 1/16 of an inch by less than 1/16 of an inch.
And so those particular pieces that you measured, about how small are we talking about?
So the largest for the red plastic, the largest piece measured, just for visual purposes, it's roughly like the size of a grain of rice. The rest of the pieces were smaller than that.
And who within the lab provided that debris in that taillight housing to your unit, to the trace unit?
So the debris from the clothing was transferred to my unit by Maureen Hartnett, and the taillight was submitted to the lab by Trooper Christopher Moore.
May I approach, Your Honor?
Yes.
Showing you a series of 5 photographs. You can review those and look up when you're finished. Generally speaking, Ms. Hammond, do you recognize what's depicted in those photographs?
Yes, I do.
And what do you recognize those?
Those are the photographs that I took of 7-18.18.
I'm going to come up to seat to introduce and admit as the next exhibit, A through E. No objection.
Thank you. It's 201 A through E.
Your Honor, may I publish?
Yes.
Ms. Gilman, if I could have photograph 9352. And Ms. Hanley, what is depicted in this photograph on the screen?
So this is one of the photos that I took of 7-18.18. This is how I received the clear piece of plastic.
And is that a tin that it's encased in at the time that you receive it?
Yes.
Ms. Gilman, if I could have 9355. And what is this, Ms. Hanley?
So this is a photo of the clear piece of plastic that was within that tin.
And Ms. Gilman, if I could have 9364. And Ms. Gilman, if you could enlarge this just a bit. Maybe just a little more, please. Thank you. And Ms. Hanley, what are we looking at in this photograph?
This is the photo that I took of the debris that was collected from the clothing items.
Ms. Gilman, if I could have 9366. And again, Ms. Hanley, what are we looking at here?
This is a photo that I took under a microscope of the red plastic pieces that I noted within the debris.
And lastly, Ms. Gilman, if we could have photograph 9369. And Ms. Hanley, what are we looking at here?
This is a picture that I took of the red plastic pieces that I removed from the debris.
Thank you. Ms. Gilman, you can take that down. Now, Ms. Hanley, in reference to your comparative analysis from item 3-1, the taillight housing plastic, to the clear and red plastic pieces of debris from debris from item 7-18.18, the clothing of Mr. O'Keefe, what types of instruments did you utilize in this comparative analysis?
Sure. So after completing my examination, I utilized a comparison microscope as well as a polarized microscope, a FTIR, which is a Fourier transform infrared spectrometer. And I also used a microspectrophotometer, also known as a microspec.
And what is a microspec?
So a microspec is an analytical tool that we can use to examine samples that have color. So it provides information on the sample's dyes and pigments.
And how is that utilized in your comparative analysis?
So I ran samples from both items that I was comparing, and I compared the data from those two items as a part of my comparative analysis.
And when you run that sort of data, can you describe for the jury sort of what that data looks like? Like what are you physically seeing when you're examining the data from a microspec?
So what we refer to it as a spectrum or just a graph. And when we do the comparison, we can overlay those spectra or graph to determine if they are consistent or not consistent.
And I know you spoke a little bit about it in your testimony yesterday, but if you could remind the jury as far as an FTIR, what is that and how is that used in your analysis?
So an FTIR is another analytical tool that we can use. A sample is exposed to infrared light and it reacts in a certain way with that light. And what's produced is a spectrum of peaks and valleys that are representative and unique to your sample. And so that instrument was used to run samples from both items, and then the data was compared from both items.
Now, from your comparison of starting with the clear plastic from the debris from Mr. O'Keefe's clothing, from your comparative analysis of that clear plastic to the clear plastic from item 3-1, the tail light, what did you conclude?
So the clear plastic from the debris was found to be consistent in color and instrumental properties to the clear plastic from the taillight. So accordingly, the clear plastic from the debris could have originated from the clear plastic from the taillight or from another source with the same characteristics.
And with reference to the red plastic from item 7-18.18 from Mr. O'Keefe's clothing, in your comparison of that red plastic with the red plastic from the passenger side taillight of the defendant's vehicle, item 3-1, what did you conclude from that analysis?
So the red plastic that I sampled from item from the debris from the clothing from 7-18.18 was found to be consistent in color, microscopic appearance and instrumental properties with the portions that I sampled from the red plastic from the taillight. So accordingly, the red plastic from item 7-18.18 could have originated from the red plastic that I sampled from the taillight or from another source with the same characteristics.
I'm sorry, Your Honor, if I could just hold on 1 minute while the sirens pass. May I approach again, Your Honor?
Yes. Actually, is this a good time to take a break, Mr. Lally? Luncheon break?
Entirely up to the court. I probably have another 3-4 minutes left.
I'm going to see counsel for 2 minutes, folks.
Bev, if you struggling to pay attention, just say that. Just say that. You know, if you having a hard time getting through this woman's testimony, Bev, just say that. Because y'all just got back from a break. Now y'all ready to go back on the break, and we done already started court late because you got issues with the jury. Nah, your chat is here. You are not blocked. Yeah, we all see you, Shay.
We're ahead of schedule, so we will take a luncheon break, and we'll take an hour. So I know
This an hour.
All rise for the court, please. Jurors, close your notebooks, follow me.
Yeah. Brennan thought that neurosurgeon was gonna take a long time, and they dragging this sucker out today. They dragging it out, and now she's talking about we're gonna be back here too. Mm-mm. Mm-mm. Let me find us something else to watch today. Cause that's why I be having a hard time with these folks. Yeah, Bev bored. Bev can't stay woke. But you know what I'm gonna do? I'm gonna actually go ahead and read Diddy tweet, and then I am going to switch us. We're gonna rewatch the cross-examination of the neurosurgeon because I missed it. Are y'all able to hear me? Let me know if you can hear me before we you know what? I think they on lunch. They were on break the last time I checked. Oh, they back. This was about the immunity stuff. All right, let me back up. We did miss some. Yep, he said he's not divorced. He's not divorced from his training. When you do forensic work, you want a lot of sources of information, right? If it's relevant, you look at police report, witness reports, and the like. Correct. You are familiar with malingering? I am. People can fabricate emotional responses. Correct. They can. Mr. Bach, should we break here? I don't have a good cliffhanger. Break. But wait, during break, they bring in George Kaplan to invoke his Fifth Amendment right against self-incrimination. Welcome. Did you receive a subpoena? Yes. Do you intend not to answer on the Fifth Amendment grounds? Yes. Your Honor, please sign the immunity order. He's read it. No, read it first. Has he read it? No, read it first. The attorney says he's read it. I will sign the immunity order. The government will seek to grant I'm guessing that's the exhibit number. They went to break. Your Honor, we emailed you about the exhibit over the break. We object to it as hearsay. The statement, I feel you, from Mr. Combs is ambiguous. He could be saying thanks for advice. We will pick up after Dr. Hughes. Please get her back on the stand. Oh, Dr. Hughes is a female. Entering jury, you are with the American Psychological Association, which says you should only render an opinion after an examination, right? And basically answers, well, where did I do that at? Where? All right, so we're gonna let that build up a little bit because they really just got back in court. Like I told y'all, I missed the cross examination, and so I do need to figure out what Alessi got out of his cross. I want to say it start around here. Is this Hank talking? Okay, this one Alessi gets up. Okay, so we're just gonna rewatch this because I missed it. And Wait a minute. No sound beta? I'm gonna stop sharing and reshare to see if you got sound. All right. Stop share and reshare.
A moment.
Okay.
Let me know if you got sound.
Mr. Wolf,
What exhibit number, Mr. Alessi?
we're going to 165, Your Honor.
Okay, go right ahead.
Thank you. Dr. Wolf, have you seen this photo depiction before today?
I believe I have.
Is it correct that that injury on the upper right eyelid is caused by the application of force directly to that area of the front of the head, again, namely the upper eyelid?
That's possible, yes.
Is it more than possible? Is it probable that that injury was caused by the application of force directly to that area of the front of his head?
Well, an easy answer to that would be is that that's not part of the periorbital ecchymosis.
Thank you, sir. That was exactly going to be my next question. This injury is unrelated to any of what you've been describing, the fall backwards, the force transfer inside the skull, the, as you described it, the dura, the cerebral spinal fluid, all of that dynamic that you so ably described on your direct examination. This injury has nothing to do with that, correct?
Correct.
I have one more moment, Your Honor. Thank you. Thank you for answering my questions, Dr. Wolf. A pleasure again. No more questions at this time, Your Honor.
Any brief follow-up on that?
No, thank you.
All right, Dr. Wolf, you're all set, so you can get out of here.
Thank you very much.
Okay. Very, very short crossing him. So not very much for us to get out of that, except what Beta threw out here for us. I ain't talked to Cassie at all. All right, let's see what the inner city press got going on over here. All right, so we'll pick up with Dr. Hughes. Please get her back on the stand. She comes in. So you're with the American Psychological Association, which says you should only render an opinion after an examination, right? Where this is, I guess they were showing something. It says this is a different role. You have not, Dr. Hughes says this is a different role. Box says you have not gathered information about this case, right? Hughes, I'm not rendering an opinion on an individual. There's someone named Cassie, but you don't know what she said, right? I don't. You're testified across the river in EDNY, right? Right. And you say the same thing. Even those, the cases are different. I'm guessing even in those, the cases are different, correct? It's to help the jurors understand, but it's their job to consider their case, right? You don't publish data on your patients you have evaluated, do you? It's confidential. So you can't cross-check your experience on the basis of what you are saying, right? Yeah. Yeah. People might go to a civil lawyer to make a little money, right? Objection. Let's move on. In civil litigation, you might look for malingering, right? Oh. 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 He said, I told you she a fraud. She out here just regurgitating information on the stand. Is what it sounds like. She go all over the place regurgitating information, but everybody's situation is different, and you really need to listen to that person's situation in order to render an opinion. But she like, I ain't really giving an opinion. I'm just saying how it worked. But how do you know if it worked if each case is different? With messy boots, y'all. Let's see what we got going on here. Nobody else is really airing anything, so I guess we're doing a roulette.
At the location of Carpenter Road near Ellsworth Road, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. That's fine, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
No.
Fines and costs of $250. I'll suspend 90 days in jail. When can you get the $250 paid?
Can y'all give me at least 60 days? I'm clearing up. I got about $1,500 in fees to pay. I'm getting all these courts out the way, and you guys were the last court that I had to get in contact with. So
you held us till last?
Say it again.
What? I said you held us till last?
I was going in order. That's all. I was just trying to get it out.
Oh, okay. So we ended up Washtenaw, so we're at the bottom. Okay.
No, y'all at the top.
Y'all
And y'all the furthest too. So
all right. Okay. Look, young man, get this paid off. I'll give you till July 31st, 2025. How's that?
Thank you.
All right. Take care.
How you so?
Court calls case People versus Shamika Grimmett.
Henry Silver on behalf of Pittsfield Township.
Assistant Public Defender Damage. Because it is due.
I think I did see her. Yep. Ms. Grimmett?
Yes, I'm here.
Okay. Need a camera. All right. What are we doing? Oh, there she is. Okay.
Thank you, Your Honor. So Ms. Grimmett had 4 tickets that were holding up her license before she could take her test again. 3 of those tickets are paid off, and one of them actually gets paid on the 4th of June. So then she can potentially take her test. That being said, I'm not trying to pick a date, but I would ask if the court would consider adjourning this out to July 2nd.
She's got a warrant out of 1484.
I did not know that, Your Honor.
For another driving while license. Yeah, for driving while license suspended charge. That occurred. The offense date of that is February 20th of 2025. So after you were arraigned on this, you picked up another ticket. It was February 20th at 11:01 p.m.
Thank you, Your Honor. Would Your Honor, I know it's not you probably can't.
I know about that ticket.
I can, but she needs to appear over there.
Yes, Your Honor.
Well, actually here, because yeah, if she appears here or sends in a warrant recall, they'll probably do that and set her another date.
Thank you, Your Honor. But she has not been arraigned on that case yet?
She actually was. Yeah, well, hang on a second. It looks like she was. You don't show it?
No, sir.
Okay, I just see the next things appearing. So she has not been arraigned. So this case, I will adjourn to the July 2nd, 2025 date, 9 a.m. I'll give her the time to do that. She's got to get that other thing clear and then get in, try to get a license back. Court,
Thank you, Your Honor.
court does call the case People versus Chelsea Hogan.
Henry Silver, on behalf of Pittsfield Township.
Defender Dan Blasey, on behalf of Ms. Hogan.
Ms. Hogan, can you state your name, please?
Chelsea Hogan.
All right, yep, she's here.
Thank you, Your Honor. I think there's a resolution in this case to which my client will be admitting responsibility for the civil infraction of failing to stop, and in exchange, the misdemeanor will be dismissed.
That's correct, Your Honor. So I move failure to stop at within an assured clear distance. MCL 257.627.
Sure.
Or 9? I think it's 7.
Okay, we'll try that. What do you have? Is that?
120.
All right. And then count one would be dismissed.
That's correct. Thank you.
All right, ma'am, do you admit responsibility to the fact that on November 10th, 2024, at a location in Pittsfield Township, that you operated a motor vehicle and that you failed to stop at a shared clear distance?
Yes, Your Honor.
All right, court will accept that admission to that count two. Count one is dismissed. Fines and cost of $120. When can you get that paid?
Can I get 14 days for that?
14 days? I think we can do that. How about June 6th?
That's perfect. Thank you.
All right, June 6th, 2025.
And
All
I
right.
checked, it is MCL 257.627.
627. All right, thank you. All right, thank you, ma'am.
Thank you, Your Honor.
Thank you.
Thank you, Hogan.
Court calls the case People versus Yusuf Jama.
Henry Silver, on behalf of Pittsfield Township.
On behalf of the state, with and on behalf of Mr. Dama, who is supposed to be assumed, can you please unmute and state your name for the record?
Yusuf Jama.
Thank you, Your Honor. I'm respectfully requesting an adjournment, I guess 2 in a row, or not quite in a row. I would be asking for the July 2nd date. Just this morning, I was able to provide some treatment verifications to Mr. Siller. We're hoping to see possibly some more information or to see how well Mr. Jama continues in that program. So I would.
So he's currently in treatment.
Yes, Your Honor.
Without objection, July 2nd, 2025, 9 a.m.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Chad Jones.
Henry Silver, on behalf of Pittsfield Township.
This is insurance.
Chad Jones. I issued an order to show cause.
Yes.
Not appearing, bench warrant will issue, bond 5,000. Give 10% privilege, that warrant will issue immediately. Court calls case of the People versus Nariman Kasham.
Henry Silver, on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Kasham, who does have a valid license and did give me permission to accept the offer on her behalf.
So, Your Honor, I moved at count 2 of double parking. If you accept that admission and dismiss the original charge.
And you having authority, you do admit responsibility to that on behalf of your client.
I do.
Court will admit responsibility to count 2 or accept responsibility. Accept the admission to responsibility under count 2. Count 1 is dismissed. Fines and costs of $180. When can that get paid?
I'd ask for 4 weeks, Your Honor.
Just cause or what?
Seems right. Seems good. Nice round number.
Pay it by June 30th, 2025. Court calls the case, People versus William Katke.
Conrad Sewell on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Katke. Mr. Katke, please state your name for the record.
William Katke.
Your Honor, we have come to a resolution. Mr. Katke is going to be pleading guilty to allowing an ineligible driver to operate a motor vehicle, 257.326. I do have an advice of rights form that he gave me permission. Never mind, I don't even need this. Mr. Schiller informed me that he's gonna give you even better offer, Mr. Katke. He's offering you to admit responsibility of double parking, which is not, it's a civil infraction, doesn't go on your driving record, doesn't go on your criminal record. It's a fine of $180.
I'm good with that.
Okay.
Later on, I think that count to double parking, if you accept that, move to dismiss your insurance.
All right, Mr. Katke, do you admit responsibility to the fact that on February 10th, 2025, location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle?
I do.
All right. Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can you get that paid, sir?
Today.
Oh, thank you. Pay that today. May want to wait till later in the afternoon to try to, if you pay it online.
Yes, sir.
Okay. All right. Thank you, sir.
Thank you.
Court calls the case, People versus Jaden Kendrick.
Conrad Sewell on behalf of Pittsfield Township.
Public Defender Natalie Pate. Oh, he is here on Zoom. With on behalf of Mr. Kendrick, who appears via Zoom. Sir, can you please state your name for the record?
Jaden Kendrick.
Thank you, Your Honor. I do not have a good phone number for Mr. Kendrick. I do have an email address, however, so I would ask first for an adjournment, and then secondarily, if Mr. Kendrick would be so kind as to call the Public Defender's Office to update his phone number.
I'll adjourn him June 18, 2025, 9 a.m. Okay? Good. You got the PD's number?
Oh, which Washtenaws?
Yeah.
I can get it.
Okay. You got to call them, make sure they have a good phone number for you.
Got it.
Okay? All right.
And this is by June
Thank
18th?
you. Yes, the 18th.
Thank you, Your Honor.
Court does call the case of the People versus Vincent Lambert.
Conrad Sewell.
Okay, no.
So this is an arraignment, Your Honor. The second case is a
Warning.
Mr. Lambert.
Vincent Lambert, no response. I have another warrant, so bench warrant will issue for defendant's failure to appear, bond $5,000. I'll give a 10% privilege. That warrant will issue immediately, given the other warrant. Court does call the case of the People versus Montez Miller.
Conrad Sewell on behalf of Pittsfield Township.
On behalf of Mr. Miller, who may be present via Zoom. I don't have Mr. So, Your Honor, I was able to, I do not have a direct number for Mr. Miller himself. I only have his mother's number and then the number of the Christian Guidance Center. I spoke with someone there. It is my understanding that he's not currently there, but has been there previously. To that end, outside of not having a direct phone number for him, so I was unable to communicate with him directly. I do not have an explanation for his failure to appear for the record. I have requested, Your Honor.
Bench warrant will issue bond 5,000, 10%.
They are here in Zoom.
They are. The court does call the case Pittsfield Township versus Guzin Han.
Here.
No, that's not you. Ms. Hung?
Go ahead. Kim Time Lê Đô. Hi, Lê Hậu.
All right. She's there. We were unable to get an interpreter through our two services. So I do not have an interpreter. Is there somebody there with her that
Yes.
So speak.
Yes, I am the daughter.
Pardon?
I am the daughter.
Okay. So since we don't have a court interpreter on this, I'm going to adjourn this out and give us time to try to find one. I'll adjourn it to July 2nd, 2025, 9 a.m. or as your invite indicates. And hopefully we can get an interpreter prior to that time. All right?
You say July 2nd?
Yes, yes, ma'am.
July 2nd, 9 a.m.?
Yes, ma'am.
Okay, thank you.
All right. Thank you.
Thank you.
Your Honor, I apologize. Mr. Siller and I very briefly approached on this regards to that issue, the
Okay, we're all set on that case. And then we're actually back on time, kind of. So court's gonna stand in recess. We'll come back to our next block shortly. Court's in recess.
All right.
Good afternoon, Your Honor.
Good afternoon, sir. You may proceed.
Thank you, Your Honor. Sir, could you state your name and spell your first and last name, please? Yes, sir. My name is Yuri Buchanek, spelled Y-U-R-I-Y, last of B-U-K-H-E-N-I-K. Where do you work, sir? I work for the Massachusetts State Police, currently assigned to the Norfolk District Attorney's Office. How long have you been with Massachusetts Police? I graduated the academy March of 2012. And how long have you been attached to the detectives unit with the District Attorney's Office? 10 years. And what is your current rank? I'm a sergeant. And how long have you been a sergeant within that unit? Since December of 2021. So I'm going to ask some questions now about January 5th of 2023, Thursday. That day, did you have the opportunity to be dispatched to Cohasset? Yes. Why were you dispatched to Cohasset? Cohasset police detectives reached out to our office requesting assistance in investigating a missing person case. What was the name of the person you were asked to help find? The person's name was Anna Walsh. About what time did you get to Cohasset PD that day? It was in the late afternoon. I would say approximately 4:45 or so. And did anyone else besides you that's a member of the State Police Detectives Unit with the Norfolk District Attorney's Office respond to Cohasset that evening? Yes. Who else? Trooper DeChico. And once Trooper DeChico and you were at the Cohasset PD, who did you have the opportunity to speak with? I spoke with Detective Harrison Schmidt of Cohasset PD. And what was the purpose of this meeting with Detective Schmidt? He gave us an update on his investigation into the missing person, shared the details of that he's learned since he was involved. Did you have the opportunity to review anything in addition to having the conversation with Detective Schmidt? Yes, I was able to review an audio recording of Brian Walsh's interview. And after having this meeting and reviewing the recording,
what did you have the opportunity to do next in your investigation?
After doing the review of the recording and being updated on all the information that Cohasset PD had at the time, myself, Trooper DeChico, Detective Schmidt, Detective Lieutenant Lopes, and Sergeant Hunt proceeded to 516 Chief Justice Cushing Highway in Cohasset.
About what time did all of you arrive at that address?
I believe it was like 6:30 p.m.
And when you arrived, was anyone leaving?
Yes, there was a female party leaving as we came up to the door.
And do you understand what her relationship was to the family?
I do know, yes.
What is it?
She was the babysitter for the 3 juvenile children.
And after seeing this woman leave the residence, did you discover who else was in the residence at this time?
Yes.
Who?
Within the residence, we were able to meet with Brian Walsh, his mother, Diana Walsh, and there was 3 juvenile children inside as well.
Now, in that evening, did you have the opportunity to conduct an interview with anyone at the Walsh residence?
Yes, I did.
Who did you initially get the chance to speak with?
Initially, I spoke with Diana Walsh.
And Diana Walsh is Mr. Brian Walsh's mother, correct?
That's correct.
All right. Where was your conversation with Diana Walsh?
My conversation was in the living room area where the couches were situated. There's also a fireplace there. It is right off the kitchen area, separating the dining room area by a staircase set and a wall, I believe.
And was there anyone with you to help conduct this interview?
Yes, Detective Lieutenant Lopes of Cohasset PD was present with me.
Where were the other officers at this point in time that arrived with you?
The other officers were speaking with Brian Walsh in the dining room area portion of the home.
And was anyone else with Mr. Walsh besides those officers, if you know?
Just the 3 officers that arrived.
Where were the children when you initially had the opportunity to speak with Diana Walsh?
Upon her request, the children went upstairs in the main portion of the home to the 2nd floor.
Now, can you explain how the initial conversation, what occurred during your initial conversation with the defendant's mother?
Yes. As we sat down, Diana was asked to provide her date of birth and the phone number. She initially ignored my request and was texting on her phone. A follow-up request was also momentarily not addressed or not answered. She then advised us that she had utmost respect for what we do, but she only has 1 son, and she was very adamant in helping find Anna.
Did she say what she was doing as far as trying to find Anna?
Yes, she stated that she had Googled, researched a top PI firm, private investigation firm in the DC area, and she had been communicating with the owner / CEO of the company.
And did she give you any contact information for that person?
Yes, she provided both a business line and a private cell phone number for the individual.
Now, did she have the opportunity in this, during this conversation, did she tell you what had occurred with her son's cell phone as far as January 1 and January 2nd?
Yes, during this conversation, she advised us that on January 2nd, Brian Walsh showed up at her home in Swampscott and advised her that his phone was missing and that he needed to use her device to communicate or try to reach Anna.
And did she show you anything from her phone during this part of the conversation?
Yes, she showed me her call logs as well as text message communications that were documented on her device.
And when you saw this, did you see the names of any of, not asking the specific name, but did you see the names of anyone in the family?
Yes, there was a name associated with a juvenile child, the eldest, that was documented as a missed call.
And did you ask her about whose phone number that would be?
Yes, I did.
And what did she explain to you?
She indicated it was the 6-year-old's a phone number as saved with the name in her device, and that she had purchased all the three of the juvenile children, cell phones, Apple AirTags, and iPads.
How long were you speaking with Diana Walsh before any of the children returned?
I would estimate it 15 minutes or so.
And which child did you wish to speak to?
The oldest 6-year-old child.
And was that one of the children that returned at this point in time?
Yes, it was.
And did you have the opportunity to speak to the oldest child?
Yes, I did.
Can you explain to us what occurred as far as that conversation?
Initially, when the child presented to our presence, myself and Detective Lieutenant Lopes asked him if he was willing to have us ask him some questions. He shook his head in the affirmative without giving me a verbal response. Diana at that point asked him to sit on her lap while we held the conversation. And we proceeded to ask him some questions.
And what did the oldest child tell you about about what he remembers as the last time he saw his mother, Anna Walsh?
What the child stated was that the last time he saw his mother was surrounded around the events of him hearing a noise, waking up, coming downstairs, and seeing her on the couch underneath his blanket, which he left in the room overnight. She was dressed in a set of pink pajamas with red hearts. And as he was walking by the kitchen island, he saw his iPad. He picked up the iPad, recognized that it was malfunctioning or broken, not working properly, and he requested that his mom, Anna, fix the iPad for him. Once she fixed the iPad, he indicated that Anna went upstairs and changed into her real clothes, returning back downstairs, holding a brown duffel bag, approximately 2 feet in length, and a purse, which he gestured to her wearing on her shoulder. He then stated that her taxi was here. He told her, "I love you." She responded, "I love you more." And she walked out the door to her ride. When asked if he saw the vehicle, saw the headlights for the vehicle, or saw her get into the vehicle, he stated he did not. Those are strictly his speculations. Obviously, he didn't use the word speculation, but.
And how did the conversation end with the oldest child?
I had a question for him asking, does he know where his mom, before I was able to finish that question, Diana became animated with her arms since he was sitting on her lap, flailing her arms in the air. I stopped abruptly, being interrupted by her gesture. She finished the question for me, stating cell phone. The child never answered my intended question, which was if he knew where his mom was, nor the question that Diana finished. He strictly said that mom wanted him to move to DC to be with her. He abruptly got up off of Diana's lap and ran into a different portion of the home.
And did you have any further conversation with the oldest child?
Yes, I did.
And what was that, sir?
At one point, a little bit later on, he returned to the area where myself and Detective Lopes was standing. He opened the door slightly, just wide enough to the basement that he could fit through. He took a step onto the first step going down into the basement, looked back at me, extended his arm, and I told him that he shouldn't go into the basement on his own, realizing there were child locks on the door. Then Diana also opened the door all the way and grabbed his hand and told him not to go down there.
Did any of the children ever give you anything that night?
Yes.
What did they give you?
The eldest 6-year-old boy gave me a little art piece that he rendered.
Now, How long were you in the home speaking to the oldest child and Diana Walsh?
I would estimate it to be 45 minutes, maybe more. It was a lengthy conversation in our presence in the home.
You may proceed.
Thank you, Your Honor. Sergeant, we left off, I believe, that the conversation had come to an end with Diana Walsh and the oldest child. What did you do at the house after that?
I waited for the other officers to finish searching the home for the missing individual, to include the attic.
Why was the attic significant to you?
It had not been searched, and in my experience with other cases, we have had located individuals in crawl spaces and attics.
What types of cases are those, sir?
Death investigations.
And more specific, though, when you found people in crawl spaces like that, have they been as a result of murder or how so?
They were suicides.
What did you do as far as examining the outside of the home?
I proceeded outside, checked the yard, the property, to include trash cans, looking for Anna's phone. One of the locations that myself, Detective Lieutenant Lopes, Detective Schmidt checked was Brian Walsh's Volvo SUV.
And did you ask anyone permission to check the Volvo?
Yes.
And who did you ask?
Brian Walsh.
And what did he say?
He complied, granted us permission, unlocked the vehicle, and we took a look through the contents of inside.
And what observations did you make of the Volvo?
I located a cell phone device inside the Volvo, located in the center console of the vehicle.
And did you have a conversation with Mr. Walsh about whose cell phone that was?
Yes, I asked him whose device that was, at which time he stated it was his oldest son's
And
phone.
did any of the police officers attempt to verify that?
Yes, Detective Lieutenant Lopes, having been provided with the phone number for that device, called the phone, and the phone rang, verifying that it is, in fact, the 6-year-old's phone.
And where did Detective Lopes get the phone number from?
Our conversation with Diana Walsh, when she showed us the call logs, the phone number was provided.
Do you remember what the phone number was for that device?
Not at the top of my head. I know that it most likely ended at 8028, possibly.
And did you write that anywhere in any of your reports?
Yes, I wrote it in my interview report.
Would that, looking at that report, refresh your recollection as to the number?
Yes, sir.
Your Honor, may I approach?
You may.
Sergeant, I ask if you would look at paragraph 9. Look at it yourself. Look up to me with an opportunity to review it. Does that refresh your recollection as to that phone number?
Yes, it does.
What was the phone number, sir?
617 895, I believe.
Oh, should I come back?
Yes, please.
All right, Sergeant. Take one more look. You know where it is. All right, now you want to give it a shot.
Yes, 617 895 8028.
So, that phone, was it seized that night?
It was not, no.
Was it left where was it left then?
In the vehicle.
Now, this is Thursday, January 5th. Is that correct?
That is correct.
Now, I'd like to, that night, besides looking in the Volvo, did you find anything else as far as cell phones that night?
No, I did not, no.
Okay. Now, I'd like to ask you now some questions about January 6th, Friday.
Yes, sir.
Did you have the opportunity to contact anyone who was representing Mr. Brian Walsh?
Yes, I did.
Who was that you were contacting?
I contacted attorney Tracy Minor.
And how did you, why were you contacting Tracy Minor?
I wanted to communicate with her and get consent for the devices that belong to Brian Walsh and his juvenile children that were being utilized.
And what was your understanding of Tracy Minor's relationship to Mr. Walsh?
My understanding was that Tracy Minor was representing Brian Walsh on a criminal matter out of federal court in Boston.
And when did you start communicating with Attorney Minor?
I began communicating with her in the afternoon hours of January 6th. It was during the 3 o'clock hour, I believe.
And how were you communicating with her?
Via cell phone call communication.
Do you know roughly how many phone calls you had with Attorney Minor?
I had numerous communications. To the best of my estimate, probably three phone calls.
And so what did you ask Attorney Minor in the first conversation, if you remember?
In the first conversation, I identified myself and asked her to provide consent for Brian Walsh's phones. At that point, I had knowledge of at least 2 devices, the one that was missing, that was located on the second, and then the 6-year-old cell phone.
Okay, so to be clear, you say the one that was missing that was located in the second, who did you believe that cell phone belonged to?
Brian Walsh.
And the second device, what was that device that you were concerned about?
That was a device that contacted Diana with a missed call on the call log, and it was also now present inside Brian Walsh's vehicle in the SUV.
What did you say to Attorney Minor that you wished to do to these devices?
I stated that we wish to do a full system extraction, phone dump, more commonly used as a phone, known as a phone dump, of those devices for digital evidence data.
And what reservations did Attorney Minor express to you in the first conversation?
She stated she needed to talk to her client, and she would call me back.
And did you explain anything else you were looking for at this point in time?
No, I did not.
So how long did it take for Attorney Minor to contact you back?
It was somewhere between 5-10 minutes, maybe a little more than 15 minutes, but I did receive a call from her within a short period of time.
And what happened in this next phone call?
She stated that it would be fine to, they would consent to the extractions. They just wanted it documented, and she requested a documentation to be generated.
And was there any limitations on the digital? Was there any limitations on what you were allowed to look at?
Yes, it was communicated verbally in our agreement that we were not to look at attorney-client communications prior to December 25th, 2022, and no communications between Anna and Brian Walsh prior to that date as well.
Besides those 2 issues, was there anything else that you were not allowed to look at when you spoke to Attorney Minor?
No.
Did you tell Attorney, and so during this conversation, was there mention of any other devices you wish to look at?
Yes, after we made the agreement for the 2 cell phones mentioned, I also requested that the iPad, which we knew was manipulated by Anna prior to her leaving the home, would also be included within the devices that were consented to.
Did you explain why you wanted to look at that iPad?
I did not know.
Why did you want to look at that iPad?
Well, if Anna manipulated the device and fixed it during the time frame that we were advised, there would be a digital footprint on the device documented that manipulation.
And to be specific, what iPad are you referring to that Anna manipulated?
It was the iPad that the 6-year-old saw on the island as he came downstairs after hearing a noise and waking up, and he picked it up and had his mom fix for him.
Why was that footprint significant to you in your investigation into the disappearance of Anna Walsh?
It would have really narrowed down the timeline of when Anna left the home. It was in short a short period of time after the device was manipulated that we were told Anna got dressed and left the home.
Had you had any access to that iPad before this conversation?
No,
And so when you were speaking to the oldest child, he never showed it to you or anything like that?
no, he did not.
Okay. Now, besides the two areas that you had agreed upon with Attorney Minor, which was attorney-client contact and anything before December 25th with the defendant and his wife, she asked for what?
A documentation of the agreement that we verbally discussed and agreed upon.
And what did you do to document the agreement?
Communications were had with Norfolk District Attorney, First Assistant Lynn Beelan, and she drafted an email including those specific restrictions of the full data extraction, digital evidence analysis in an email form and sent it to Attorney Minor and CC'd me on it as well.
What memory do you have of expressing these concerns to First Assistant Beelan at the time?
I do not have a memory of communicating with First Assistant Beelan.
So do you know how First Assistant Beelan knew to send the email?
I do not know.
Your Honor, may I approach?
You may.
Sergeant, do you recognize that document I've just handed you?
Yes, I do.
What is the document I've just handed to you?
It's a copy of a printed out email exchange between Attorney Minor, which I'm CC'd on, and First Assistant Lynn Beelan, and their communications.
And does that document, is that after you had had the conversations with Attorney Minor?
Yes, it is.
Your Honor, I'd ask that this be marked as the next exhibit, and I know that I've fouled up the order, but it is in the binder, and I think it was attached to the defense's pleadings as well.
All right.
Thank you, Your Honor.
And what number do you think it is?
So on my listing, I have it as Exhibit 13.
Exhibit 13. You know what he's talking about, Attorney Tipton?
Yes.
And do you have any objection to that?
I do not.
All right.
I feel a little bit better right now that he knows what I'm talking about, which is great. So, Sergeant, if I may ask, could you read the first email into the record of that chain? First is, who is the sender?
The sender is Lynn Beeland.
Who are the recipients?
It is addressed to Tracy Minor, and I am CC'd on that email.
What is the date and time of the email?
The date is January 6th of 2023, and the time is 3:39 p.m.
And can you read the body of the email?
Yes, sir. Attorney Minor, as requested, the Norfolk District Attorney's Office agrees that in the investigation to Anna Walsh, any conversation between the attorney and client, Brian Walsh, is excluded from the search and examination of Brian Walsh's phone and the minor child's iPad. It is further agreed that any conversation between Brian Walsh and his wife, Anna Walsh, 1 week before she was missing, 12/25/22 and prior, shall be excluded from the search and examination of Brian Walsh's phone and the minor child's iPad. Should you have any questions, please contact me, Lynn Beelan, First Assistant District Attorney, Norfolk County, and the phone number.
And just for the record, when you say minor child, you are putting that in there opposed to reading the child's name?
Yes, sir.
Now, was there a response to that email that's in the chain?
Yes, there is.
Can you read the response, sir?
The response is, we consent to all communications on or after 12/25. If you want to go back further than that, I will have to get you a list of attorneys, as he has used a bunch of them.
And is there a subsequent response to that?
Yes, there is.
And can you read that into the record?
That date is fine, thank you.
And that was sent from whom?
That was sent from Lynn Beelan.
Did you receive any further email communication from First Assistant Beeland and Minor after that third entry into the email chain?
I have not known.
Now, once that was done, those emails had been exchanged. What did you do as far as trying to get the iPads or trying to get the devices?
I didn't do anything about trying to get the devices.
Why didn't you go get them?
I was tasked with traveling out of state, and I was not going to be present.
Where were you supposed to go as a result of traveling out of state?
I was traveling to Washington, D.C.
Why were you going to Washington, D.C.?
The information we had at the time and the multiple reports of on coming from D.C., living in D.C., and having traveled back to D.C. Based on my conversation with Diana Walsh, I traveled to D.C. to go find Anna.
Did you meet up with anyone in law enforcement to help you in D.C.?
Yes.
Who?
It was Detective Lieutenant Lopes and 2 troopers from another unit on the state police.
Now, so after the email exchange comes through, who do you inform that you've now received permission from Attorney Minor?
I informed Lieutenant Fanning.
And who is Lieutenant Fanning in the chain of command of the detectives unit?
He was the executive officer at the time in the unit.
And where were you when you informed Lieutenant Fanning?
I was in the command post.
And where was the command post located?
It was located a short distance down the street from 516 Chief Justice Cushing Highway in a shopping plaza parking lot behind the stores.
Now, when you informed Lieutenant Fanning, were you talking to him in person or was this over the phone or whatnot?
It was in person.
So at the command post on the late afternoon of Friday, January 6th, how many state troopers were in and around this area at this point in time?
There were dozens and dozens.
And so are you aware of who collected the devices from Brian Walsh on January 6th?
I am not aware now.
So you didn't go to collect the devices?
No, I did not.
When did you return from Washington, D.C.?
It was during the late evening hours of January 8th. It was Sunday, I believe, if I'm not mistaken on the date.
And did you have any further conversation with Attorney Minor about the devices after the phone calls and the emails?
No, I did not.
So after the email chain is done, do you have any further phone calls?
No.
And to be specific, with Attorney Minor?
No.
And going back to the second phone call, you told Attorney Minor that you wanted to look at the iPad?
Yes.
And can you just tell us what you told her about wanting to look at the iPad?
The conversation about the extractions of full data extraction was in reference to the 2 cell phones. We went into detail about that. Once she consented to those cell phones, I asked if we could also do the same with the iPad.
Was there any concerns about communications on the iPad?
No, there was not.
Did you explain to her whose iPad it was?
Yes, I did.
And when you explained to her, who did you tell was the user of the iPad?
I told her that based on my understanding, it was the 6-year-old juvenile.
And did you tell her did you tell her anything further about the use of the iPad and why you were looking at it?
No, I did not.
One moment, Your Honor.
Yes?
Thank you, Your Honor. Nothing further, Your Honor.
Ross?
Good afternoon, sir.
On direct examination, you described your interaction with Diane Walsh.
Yes, sir.
And so you were involved in interviewing Diana Walsh along with the 6-year-old son.
At portions of it, yes.
When you say portions of it, what portions?
The 6-year-old was not present during the entire interview with Diana.
But you were present for the entire interview with Diana Walsh.
I was.
You didn't have any involvement in the interview Mr. Walsh on January 5th?
No, not the official interview. I just introduced myself and met him. Brief communication verbally, not a formal interview.
Did you arrive at the home at the same time with the other officers who eventually did conduct an interview with Mr. Walsh on January 5th?
If I'm not mistaken, we all arrived together, yes, sir.
So you were sitting, is it fair to say that during these two different interviews, you were in different rooms?
Yes, we were separated. The two rooms are separated by the stairwell or staircase and a wall, I believe, in the home. That's right in the middle of the building. But there's a open space for the front and the rear through the kitchen.
It's fair to say then that there were times during these interviews that you could hear people asking Mr. Walsh questions, correct?
To be accurate, because we were having our own conversation, I merely heard voices. I could not hear the specifics of their conversation or who was speaking.
And it's entirely accurate, isn't it, to say that the entire time that you talked to Diane Walsh, that Mr. Walsh, Mr. Brian Walsh, he was never present for any of that, correct?
With our conversation, sir? No, he was not.
So when you were asked all these questions on direct examination, and you were describing the behaviors of Diane Walsh as you interpreted them, it's fair to say that Mr. Walsh had nothing to do with any of those behaviors of Diane Walsh that you were observing.
Are you asking if he was influencing her behavior?
Yeah.
I could not suggest that, no.
And I mean, she is the grandmother of this the 6-year-old that you were also talking to, right?
That's my understanding, yes, sir.
And this 6-year-old was telling you, in his own words, what he remembered about seeing his mother, correct?
Yes, the information.
Thank you. This court's back in session. Please be seated.
Whenever you're ready, Mr. Allen.
Thank you, Your Honor. Now, Ms. Hanley, when we left off, you were discussing the comparative analysis you did between item 7-18.18, Mr. O'Keefe's clothing, and item 3-1, the taillight housing or the plastic within the taillight housing of the defendant's car, correct?
Correct.
And there were a number of different instruments that you used through the course of your examination and analysis, correct?
That's correct.
And what were those instruments that you used again in that portion of the analysis?
Sure. So I used a polarized light microscope, a comparison microscope, an FTIR, and a microspec.
And Your Honor, may I approach?
Yes.
Showing you 3 documents, if you could review those a couple of minutes, please. And do you recognize those?
Yes, I do.
And starting with the first.
And the clear plastic from item 7-18.18.
If I could direct your attention to the second page within that, what do you recognize that?
So this is also FTIR comparison data from for the red plastic from item 3-1 and item 7-18.18.
And lastly, the third page within that set, what do you recognize that?
So this is the comparison data from the microspec from the red plastic from the item 3-1 and the red plastic from 7-18.18.
You want to come up and seek to introduce and admit as the next three exhibits individually?
No objection, Your Honor.
All right, thank you. You want them marked individually or are you going to set?
Individually, please. Thank you.
Exhibits 202, 203, and 204. Thank you.
And again, Ms. Hanley, when it came to your analysis of the clear plastic material from the debris from John O'Keefe's clothing and the clear plastic material from the defendant's taillight, what were your conclusions from that analysis?
Sure. Upon comparison, the clear plastic from item 7-18.18 was found to be consistent in color and instrumental properties with the clear plastic from item 3-1. Accordingly, the clear plastic from 7-18.18 could have originated from the clear plastic from item 3-1 or from another source with the same characteristics.
Thank you. Your Honor, may I publish, and I'm sorry, I forgot already the
Yes.
exhibit numbers, but
Yes.
Ms. Gilman, if I could have the clear plastic. And Ms. Hanley, can you describe for the jury what we're looking at in this, what's up on the screen right now?
Sure. So this is the FTIR comparison data of the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And Ms. Hanley, if you could, using the laser pointer before you, if you could direct the jury's attention to which is which as far as the top and bottom.
Sorry. The top,
Sorry, I apologize, Your Honor.
That's okay.
the top spectrum is item 3-1 and the bottom spectrum is item 7-18.18.
And Ms. Hanley, when you're comparing these two as far as the data that you receive, what is it specifically that you're looking at in your comparison as far as the data is concerned?
So when I'm comparing the spectra, I'm looking at the peaks in each sample to determine if they are consistent or not consistent.
Thank you. And if I could turn your attention to the red plastic material from the debris from Mr. O'Keefe's clothing and the red plastic from the passenger side taillight of the defendant's vehicle, what did you conclude in your analysis there?
So upon comparison, the red plastic from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the red plastic from item 3-1. So accordingly, the red plastic from 7-18.18 could have originated from the red plastic from item 3-1 or from another source with the same characteristics.
Thank you. And Ms. Gilman, if I could have the red plastic data. And Ms. Hanley, directing your attention to the screen again with the laser pointer, if you could delineate for the jury as far as which set of data is associated with which item.
So the top spectrum is item 3-1 and the bottom spectrum is item 7-18.18.
And again, if you could just direct the jury's attention with that laser pointer to the areas as far as the data peaks and valleys that you're looking at in comparison of this data.
So when I'm comparing them, I'm comparing the peaks to each other in each of the spectra to determine if they are consistent or not consistent.
And in this case, you found them to be consistent. Is that correct?
That's correct.
And Ms. Gilman, lastly, if I could have the microspec data. And Ms. Hanley, if you could describe for the jury, please, what are we looking at in this particular data set?
So this is the comparison data from the microspec of the red plastic from item 3-1 and the red plastic from 7-18.18.
And as far as the data in any microspec, but particularly this one up on the screen, using that laser pointer, could you illustrate to the jury sort of what these individual lines or what this data means?
So these are the samples that I ran, and they samples that I ran from item 3-1 and 7-18.18, and the spectra are overlaid in order to determine, to look at it and to determine whether they have a consistent or not consistent pattern.
And from overlaying the data from the pieces of plastic from Mr. O'Keefe's clothing and the pieces of plastic from the defendant's taillight, what do you observe as far as from overlaying those two sort of data points?
So I determined that they had consistent microspec data.
Again, if you could just remind the jury as far as the microspec data, what type of data is that?
So the microspec, it analyzes samples that have color. So it provides information of a sample's dyes or pigments.
Thank you very much. Ms. Gilman, you can take that down. Thank you, Ms. Hanley. I have no further questions, Your Honor.
Okay.
Good afternoon, Ms. Hanley.
Good afternoon.
Nice to see you again. We met about a year ago. First things first, you were just talking about some plastic pieces in 7-18.8, correct?
It was 7-18.18.
0.18. I left the one out. 7-18.18. We're dealing with a lot of numbers. I'm going to see if we can cut through that here in a second.
Sure.
First of all, you indicated that you were doing a comparative analysis in different sort of different categorical ways, using microscopy, using the microspec, using the FTIR. I think you also use the FTIR in that as well.
Yes.
And you indicated that your analysis concluded with those pieces could have come from the same source, from the source in 3-1, the taillight. But you're not conclusively saying they did, correct?
It could have come from, they could have a common origin, or it could have come from another source with the same characteristics.
Right. So in other words, another way to say that, Ms. Hanley, is it may have come from the taillight, may not have.
It's a possibility.
Okay. I also want to ask you real quick about the taillight manufacturer. You were shown an exhibit. I think it's exhibit 200, and I think we have that available. With the court's permission, we don't have to cut the lights. I think the lighting is just fine. This is exhibit, or a photograph of exhibit 200 that you saw just a second ago. Quick question about that. In your inspection of that taillight, it's true, is it not, that is manufactured entirely of plastic or plasticine pieces? There is no glass in that taillight, correct?
I have to check my notes. I don't think I noted any glass.
Okay. So in other words, you didn't note any glass inherent in the manufacture of that taillight. It's basically plastic.
Yeah, I think most of the parts were plastic. I'm not 100% sure if the entire thing was plastic. There may have been other material, but portions were plastic.
But you certainly didn't see any glass inherent in the manufacture process.
I'd have to double check my notes, but I don't think I did.
Okay.
Do you want her to check her notes?
Why don't you?
No problem.
Are your notes in front of you?
Yes.
With the court's permission.
Yes, sure.
Okay, so I did not make any notation that I noted portions that were glass.
Great. Final point before we get into the actual analysis. On any of the glass, I want to shift gears to just the glass material that you analyzed and that you looked at and you inspected. You saw no blood, no skin, no biological material, no tissue, human tissue or otherwise, on any of those pieces that you inspected, did you?
Upon examination of those items, making observations of those types of material, that's not my area of expertise. I don't think I noted anything that was maybe consistent with that.
So in other words, even though you're not in the bio material expert section of the lab, you certainly would have noted if there was skin or biological material or obvious blood on glass pieces. You were looking at them in many cases through a stereo microscope, correct?
Yes, I would have made note of observations of anything that I would have noted on the surface.
Great, and you did not, because you didn't see anything suggestive of that, right?
I think I just made note. I have to check each item, but I think I did note that there was some dirt debris on some of the items.
But not biological material.
I did not note anything that would be maybe consistent with that.
Great, thank you. I want to talk about the comparisons that you did. And you'll forgive me, I'm a visual learner. So I'd like to talk about it in 4 categories.
Okay.
Linear categories. Category 1, item 3-2. Category 2, item 3-3. Category 3, item 7-12. Category 4, item 7-14. 3, 2, 3, 3, 7, 12, 7, 14. Can we talk about them in those particulars?
Sure.
Okay. 3-2 was the cup, correct?
That's correct.
Okay. And I'm going to use the word cup rather than glass for obvious reasons. You could get confused by that. So when I say the cup, do you know what I'm talking about?
Item 3-2.
Great. 3-3 are the 5 items that were found on the bumper, claimed to have been found on the bumper by MSP or crime. Okay?
Yes.
5 items, A, B, C, D, and E, correct?
Correct.
Item 7-12 are 9 items, glass items, that were recovered at 34 Fairview by Trooper Buchanan in an evidence envelope, correct?
So sustained as to who they were recovered from.
Sure. Did you receive the items along with an evidence envelope?
I need to double check if it was an envelope, but I received it packaged.
Okay. And the packaging normally, under normal circumstances, the packaging comes with labels. It gives you reference about where things came from. For instance, when Mr. Lally asked you, were you aware, or did you become aware that items were claimed to have been found on the bumper? You didn't actually find those items, but that was the description you were given, correct?
That was the description of the item in our limb system.
Okay, and going back to 7-12, that's our third category. Was that described as 9 pieces of glass that were found at 34 Fairview by a sergeant by the name of Buchanan? Or do you recall that?
I am not sure who recovered them.
Or what it said on the evidence envelope? That's what I'm asking.
I would have to check my photos to see if it says that.
We'll get to that in just a second, but fair enough. 7-12, 9 items, A, B, C, D, E. And if my memory serves, I, K, and L.
I'd have to refer to my notes to.
Can you please?
Yes. So the 9 pieces of glass from 7-12 were labeled A, B, C, D, E, F, I, K, and L.
Great. And then finally, what was in 7-14, that's an easy one, 1 piece of glass.
That's correct.
Okay. Your Honor, may I approach?
Yes.
If I could, Ms. Hanley, I'm going to hand you photographs. That should be 2 photographs of the exact same thing. Do you recognize what's depicted in that photograph?
I've never seen. I did not take this photo.
Understood.
So I'm not. I haven't seen them, so I don't know.
So I'm asking you to look. I know you haven't seen
Yeah.
that photo. Does it look like the cup?
It looks consistent with the cup.
Okay. Just gonna set this one aside for a second. Take a look at the second photo. Do you recognize what's depicted in that photo?
So I did not take this photo. It appears to be a photo of a container that another analyst took a photo of item 7-12.
And item 7-12 once again included plastic pieces and 9 glass pieces, correct?
Correct.
Do you see the evidence label on the very top of that evidence envelope?
I'm not sure which label you're talking
The
about.
one
Oh,
under the red tape.
yes.
Does that appear to be a label marker that's done to maintain chain of custody?
So I think that label. Sorry.
Sure, can we bring these over to the side?
Sure.
She's absolutely nervous. She does not want to be up there. You can 100% tell that. I think that AJ is doing a good job of trying to get it across to the jury that they claim that he's got blood on him. He's got blood on his body. There's no biological material been noted on these pieces. Sorry, I'm like trying to get this thing. Get this thing going. I guess I gotta use this little silly one right here. I really don't like it. Yeah, let's do this one. Okay. I'm just sending this to the person. All right. Who else I gotta send one of these things to? Who else is doing a good job? Let's go to I want to give one to so we have to give out like awards to people. We gotta like give people kudos every month for whatever reason, which is kind of corny. And so I'm trying to get mine done so they can stop pinging me, talking about you haven't given out any awards, any points this month. So what? You don't care. Okay, I've given away all my points. But the thing about this too is that people don't give me points. But I really feel like I shouldn't have to give people points. They don't give me nothing. Okay? They don't even like to tell me happy birthday. They make it seem like I'm just this extra mean person, and I'm not. Okay, you only really have to give out points to like 3 people, or you can give one person all your points, but then they shame you for doing that, right? Now I'm just ranting. They shame you for doing that, but it's an option. You don't want me to give out my points to somebody, then don't let me give out my points to somebody. It's just an interesting thing. But I will say, if you collect a lot of points, you can redeem them for a lot of cool stuff. Like I've gotten like company hats, shirts. I had a bunch of points. I had a bunch of points racking up. I didn't even know that we could redeem them for stuff. I ended up getting like
sometimes we're at sidebar in an effort to try and speed things up. So even though we take your time that way, this should make things move a little easier.
So you can cut that, come back and
Thank you. Ms. Hanley, I was asking you previously, we already looked at what's been marked for identification as triple G. I was asking you about what has now been marked as triple H. If you'll just look at that, what I'm most interested in is, do you see a name, a trooper's name in the middle of that evidence bag?
Yes, I do.
Is that Buchanan?
It looks like it says that, yeah.
Okay, and just so we're clear, that bag is associated with 7-12 of your analysis. The item 7-12, correct?
Yes, again, I didn't take this photo, but I have,
I
yeah.
realize that. It says 7-12
Yeah.
right on the photo. doesn't it?
Yes, yeah.
Okay, that's all I need. Taking a look at what's been marked as triple I for identification. Do you see a name associated with that evidence bag?
Yes.
What name is that?
It's actually a little hard to read. It looks like it says, it could say Trooper Proctor.
Okay, and that is associated with 7-14, our fourth category, correct?
It is labeled as, excuse me, 7-14.
Thank you. And finally, does that, which has been marked as, for identification at least, as triple J, does that appear to be the contents of that bag, which is a single piece of glass in 7-14?
This appears to be the photo that the analyst prior to me took of item 7-14.
And that would be analyst Valier.
Correct.
You see her initials there.
Yes.
Okay, thank you. So the four categories, just so we're clear and we can stop using so many numbers because they can get confusing. 3-2 is the cup, right?
Yes.
3-3 is the bumper glass, correct?
That is correct.
7-12 is the Buchnick glass, correct? You just looked at it.
Yes.
Okay. 7-14 is the Proctor glass, the single piece, correct?
Correct.
So when I make reference to those items by those names, you'll know what I'm talking about.
Yeah. Yes.
Hesitant.
No, I just, I'm just used to referring to them to the item numbers, but I will try to stay with you.
My brain will melt if we continue that way.
Can she do it both, Mr. Jackson?
Sure. Any way that you wish. I have another document that I would like to approach with, if I could, with the court's permission.
Okay.
Thank you. I'd like you to take a look at that. You've got a copy of this. Have you ever seen that before, or a variation of it?
Yes.
Okay. Saw it last year, correct? Or something close to it last year?
Yeah, it looks consistent.
Okay.
Okay. If there are any others, Mr. Jackson, why don't we bring all the
This is it.
All right, let's get through some of these Diddy tweets while we are waiting for them to come back from the sidebar. So remember that the doctors on the stand, and they were kind of talking about, you know, what they're looking for, right? Maybe looking for a little malingering, right? You gave a webinar about giving expert witness testimony, right? Making sure I ain't on mute, right? Yes, for battered women. Let me show you DX sidebar. During the cyborg exhibit from Star Island Raid with the baby oil and Astro Glide. So basically, they just showed us the photo of the stuff that they found. And that is crazy. They going through bottles of baby oil like that. We're going to send you to the jury room for a bit. All rise. The jurors leave. Yesterday, Ms. Shapiro submitted an exhibit ex parte. Now, reviewing a document, what should I focus on? It shouldn't show this witness has a bias. She can be shown the document about training domestic violence advocates and asked if she remembers, but I won't admit it as evidence until she denied it and it becomes prior inconsistent statement.
So I think I gave somebody the copy that I was using. I need a copy.
If I may approach?
Yes. Thank you. All right, so let's mark this first for identification.
Happy to.
KKK for ID.
Ms. Hanley, if I could ask you very briefly, I want to go through this chalk with you for a moment. Do you recognize something on the left? Looking at the first category. Do you see 3-2?
Yes.
How is that described?
It's described as a cup.
Okay, and you see that there's a photographic representation of the cup just above it, correct?
It looks consistent with.
Okay. Moving to the second category. What category is that?
It's item 3-3.
And 3-3, first of all, there's a photograph above it. Do you see that?
Yes.
It appears to be of a bumper, correct?
Yes.
You didn't take that picture.
I did not.
Okay, let's look down beneath it. You indicated that there were 5 items in 3-3, A, B, C, D, and E, correct?
Correct.
Do you see A, B, C, D, and E represented in that category on this chalk?
I do see A, B, C, D, E categorized, yes.
Great. Under A, you previously testified that the bumper glass sub A in 3-3 did not match the cup, correct?
That's correct.
Did not match anything in 7-12?
Sorry, just give me one moment. That's correct.
And did not match anything in 7-14?
That's correct.
And you see those represented by sort of the international symbol for negative, correct? A circle with a line through it. Correct?
Yes.
Okay. Under subcategory B, glass B, or item 3-3B, did not match the cup, did not match 7-12, did not match 7-14.
That's correct.
Is that accurately represented on the chalk?
Yes.
Finally, with regard to E as an echo in that same item, 3-3, you see that there is a green indication that glass recovered by Proctor does match, or did match in your analysis, or was consistent with the item in 7-14, correct?
It was consistent microscopically and instrumentally.
Does that accurately reflect that finding on this chalk?
Yes.
Okay, now turning to category 3. There were 9 pieces of glass that you looked at, correct?
Correct.
A through F, I, K, and L. Is that right?
If I could just reference my report to make sure.
Of course.
Yes, those are the correct letters.
And A, B, C, D, F, and K all matched the cup, correct?
Again, I would just need to confirm with my report.
Take your time.
Yes, so A, B, C, D, F, and K
All matched the cup.
had a physical match to 3-2, the cup.
Is that accurately represented on this chart? With green.
Yes,
And E is in Echo, I is in India, and I think that's L is in Lima, did not match the cup, correct?
that's correct.
Okay, is that accurately represented on this chart?
Yes,
And finally, the last category, 7-14, that is the single piece of glass that was recovered by Trooper Proctor. That did not match the cup, and it did not match anything in 7-12, correct? And if you need to check your notes, feel free.
yes, that's correct.
Is that accurately represented on the chart?
Yes,
Your Honor, I would move for the admission with the amendment that the court indicated at sidebar of triple K.
Okay, I'm going to allow it in. 205.
205? Your Honor, the court indicated that it would like to see us before anything's published to the jurors.
Okay, come on over for a second. Actually, have those have those been done?
It has been done, and I was going to explain at sidebar.
All right, then come on over. $205.
Thank you. Request permission to publish.
Yes.
Ms. Hanley, you see the chalk that's been, or actually what's been marked as Exhibit 205 in evidence on the screen?
yes,
Is that consistent with what you and I were just talking about at the witness stand?
yes,
If you'll direct your attention to the screen on the right, just because it's a little easier and I think the laser pointer shows up a little better. You see the 4 categories represented in this exhibit?
yes,
Okay, so 3-2, I'm going to go over it very quickly one more time, just visually. 3-2 on the left is the cup, correct?
yes,
3-3 represents the 5 pieces of glass of what we call the bumper glass, A, B, C, D, and E, correct?
yes,
7-12 is the 9 pieces of glass recovered by Trooper Buchanan at 34 Fairview, correct?
yes,
And finally, 7-14 is the single piece of glass recovered by Trooper Proctor, correct?
Yes.
Taking these one by one, just so everybody see. Taking these one by one, looking at starting with the bumper glass, category 2. Piece A did not match the cup, anything in 712 or anything in 714, correct?
That's correct.
Piece B did not match the cup, did not match anything in 712, did not match anything in 714, correct?
That's correct.
And moving over to category 3, there were some matches in these 9 items, 6 of them, A, B, C, D, F, and K, correct?
Yes.
But what those matched, Ms. Hanley, with a cup, nothing on the bumper, correct?
Correct.
And what didn't match the cup were E, I, and L. Is that right?
That's correct.
Moving back to category 2, however, there was one thing, item E, that did match something in this series of categories. Isn't that right?
Not a physical match, but instrumentally there was consistency.
All right. And this was an item, the only piece of bumper glass, the only piece of bumper glass to match anything else in your analysis. Matched what? Or was consistent with what?
Item 3-3, piece E, was consistent in physical and instrumental properties with the sample that I took from item 7-14.
Which is the single piece of glass recovered by Michael Proctor, correct?
Yes.
But not a single piece of glass, nothing that you analyzed coming from that bumper matched the cup. Did it? Nothing.
Physical match comparison, there was no physical match comparison to the cup.
Are we done with this, Mr. Jackson?
We can take this down, Your Honor. Your Honor, that's all I have.
Okay.
Thank you.
Mr. Lally?
Now, Ms. Hanley, as far as you were asked some questions on cross-examination about biological pieces or tissue or things being on the glass, and you referenced that that was done in another unit, correct?
Yes, if that type of examination was needed, that would be done in a different unit.
Objection, Your Honor.
I'm going to allow that, but next question.
Which unit would that be conducted in?
Objection.
So the objection sustained. You need more, Mr. Lally, before you move on.
Now, as far as the chalk that you were just presented, as far as the 4 photographs that were depicted in there, have you ever seen any of those 4 photographs before?
No.
Do you know specifically who or where any of the items 3-2, 3-3, 7-12, or 7-4 were physically recovered from?
I just have the description that's put in the LIMS system when it's submitted to the lab.
And do you know that 3-2, the drinking glass, was recovered by the Canton Police Department on January 29th, 2022?
Objection.
Sustained.
Do you know that item 3-3, the bumper glass, was recovered by Ms. Maureen Hartnett from your lab on February 1st, 2022?
Sustained.
Do you know that each of the 4 items were recovered by different people on different dates at different locations?
Yes.
Did Mama O'Keefe had that same shirt on yesterday, or am I tripping? That was just me looking at her from earlier. I feel like she wore stripes a lot in a cardigan. Maybe I'm tripping. Yeah, Jay. Proctor was out here playing. Okay. So basically, over on the Diddy tweets, we were talking about how they wanted to show the photos. If she couldn't recognize it, then it becomes a prior inconsistent statement. So she comes back in. Does this document refresh your recollection? Let me look at it more closely. Yes. The 4th part is about navigating cross-examination, right? Yes. Most of your income comes from court-related work, right? No, maybe half. You've raised your rate to $600. It's been the same for some time, but you've raised it. Here they go, and now they back. Oh man, can y'all hear?
Item 3-3, the bumper glass, was consistent with the single piece from item 7-14 that was found in the roadway outside of 34 Fairview Road. Is that correct?
Yes, that's correct.
And you also found that items from 7-18.18, the debris from Mr. O'Keefe's clothing, were consistent with the item 3-1, the taillight housing, correct?
Objection, Your Honor.
Sustained as to form.
Now, as far as the chalk that you were presented with on cross-examination, was there anything in there about item 7-18.18 or item 3-1, either the taillight housing or the debris from Mr. O'Keefe's clothing?
No, there was not.
Nothing further.
Anything?
Very briefly. So in sum, not a single piece of glass on that bumper could be connected to that cup, correct?
There was no physical match to the pieces that I compared for physical match from the bumper. There was no physical match to the glass cup 3-2.
Thank you. So another way of saying that is not a single piece of glass that you analyzed on that bumper matched that cup, correct?
Sustained.
But the one piece of glass that did match something came from the same source, it was consistent with coming from the same source as the single piece of glass recovered when in possession of or bagged by Trooper Michael Proctor, correct?
It was consistent with item 7-14.
That's all.
All right, Ms. Hanley, you are all set. I'm going to see counsel for a minute. Feel free to stand up and stretch.
Here she go. Now she about to end court for the day because Brennan ain't got nobody else to call to the stand. All right. You've been retained hundreds of times, but you've never come into court and testified in defense of a man accused of a sex crime. That's correct. I don't evaluate offenders. You met with the prosecutor 6 times to prepare your testimony, right? Correct. Can we have a sidebar? You may. Did you discuss the topics with the prosecutors? With all due respect, it was mostly me educating them, but you know nothing about the case. You were advising them on how to present evidence in domestic violence cases. Didn't you help them write briefs? Can we have a sidebar? Yes, but I'll keep it brief, shorter than the last. Apparently, it wasn't short. Sorry, that wasn't shorter. You reviewed some filings to the court in this case. It was all related to the subject of your expert testimony, right? Correct. In fact, we redacted. You did. You are a board certified forensic psychologist, right? Yes. How many of those are in? How many of those are there in New York State? I think about 40. Recross. Your defense work is almost entirely for victims of domestic violence, right? I'm not sure that's true. You work with Mr. Brian Steele, who was defending a woman charged with reacting to domestic violence, right? Yes. And Mr. Steele decided not to use you after meeting with you. Move on. No further questions. Next witness. The government calls George Kaplan. When did you work for Combs Enterprises? 2013 to 2015. What fell under that holding company? Clothing, liquor, entertainment. I was executive assistant to the chief operating officer. Where did you work? 1710 Broadway, New York City. What was your next position? Executive assistant to chairman, Mr. Combs, from September 2014 to September 2015. Who did you report to? KK. Essentially ran Mr. Combs' life. Where did you report? LA.
We don't like it when we're at sidebar, but I can tell you that after speaking to the lawyers now, we're ahead of schedule. And they've worked very hard to get us to this.
Oh, they about to go home. Get to the point.
So that tomorrow, instead of being a half a day, you have tomorrow off.
Oh,
So you have
damn.
tomorrow and Friday, a good long weekend. It's very, very important. Do not discuss
Girl,
this case.
the day over.
Don't say a word about this case. Don't let anybody say anything to you about this case. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. I believe next week, except for Thursday, are full days every day. Watch your social media.
Girl, how y'all working on Memorial Day?
Great long
Girl,
weekend.
nobody
See you
coming in there.
Tuesday morning, ready to go.
Oh, okay.
Court, all rise to the jury.
Bear said we finna have a long, long, long weekend. Stop playing with me.
Goodbye.
Okay. I guess we're gonna see if they put anything on the record. I highly doubt it. Highly doubt it. I don't think that I agree with D Wood, y'all. I don't think that they anticipated that Surgeon being as short as he was. I really don't. Where did you report? LA. What did you do? Carried his bags, made such things where when he wanted them, as he trusted me more, he had me around more. Wait a minute.
Actually, the interview evidence 205. We're in the process of printing a new one. The one that actually went into evidence is not the one that we showed.
Okay.
Instructions. We'll get that printed to you. I think before we leave. I think he's printing it now.
Right. I'd like it before we leave. So before you leave. So, all right. All right. Have a good weekend.
Thank you, Court, all rise.
All right, we done with Biff. Excuse me. Carried his bags. Made such things where when he wanted them, as he trusted me more, he had me around more. I set up hotel rooms. How many hours a week? 80 to 100 hours a week. How much did you get paid? 125,000 a year to start. What did you do in the morning? Make sure everything was in the bathroom. The breakfast cooked. He was recording a mixtape, so we worked late. Who was security? Uncle Polly, D-Rock, Ruben, later licensed security in the second half of 2015. How frequently did you communicate with Mr. Combs? Multiple times a day. Things could be found in the back, an iPad, drugs, whatever. Did he threaten you? He threatened my job. How often? Maybe monthly. He'd say he was only to be surrounded by the best people and that he wasn't. For example, he went me for a 1 liter water. I think it's supposed to he went at me for a 1 liter water and I brought back 2 half liters. He said no. Okay, maybe he sent me. He sent me for a 1 liter water and I brought back a two 2 half liters. He said no. How did you travel? On his jet or going in? How did you travel? On his jet or going in advance to make sure all is set up? How did you set up hotel rooms? There was a bag. I unpacked clothes, candles, Astroglide, baby oil. Who bought this? Often me. In what cities did you set up hotel rooms? Names off a lot of places. Okay. LA, New York, Miami, LA, Mr. C, Bel Air, the Intercontinental. In New York, Trump, by Columbus Circle. In Miami, SLS. How was it booked? Frank Black, based on Frank White. I don't know what that means. Maybe I'm too young. What would you clean up rooms? Yes. Bottles of baby oil, Gatorade, once brown crystallized powder on the counter of a bathroom sink. Why did you clean up and not the hotel staff? It was implied, protect his public image. I was keen to doing that. Explain. Objection. Overruled. I found hotels would sell photos to newspapers to shame guests. Did he reach out to you from the room for food, clothes, sometimes drugs? I did it. What drugs? DOP kit. Illegal drugs. I object to the term illegal. What other drugs? Advil, ketamine. What's he asked for? What did he ask for? I don't know. I pick up drugs for him. MDMA. Who asked? Mr. Combs in LA and Miami. In Miami, Mr. Combs asked me to call a person. He came and gave me a bag of pills, MDMA. I gave him cash. I gave the pills to Mr. Combs. And in LA, I went out to meet a person in Hollywood. I gave money and he gave me a bag. All right, let's jump over here just to kind of see a little bit more what was said. I think we kind of really covered this, right? He was never representing anybody of a sex crime, and she making $600 an hour for her work. Okay. They haven't posted anything since Kaplan has taken the stand. So yes, Brian decided not to use Don, which was very interesting. I wonder why. Judge will break for the day. Damn, everybody done. Everybody said they through. They are through piece. We don't got no Karen Reed tomorrow, so I'm not 100. I'm not 100% sure if I'm going to stream tomorrow. I probably won't, because we're already struggling to find things to watch. They got Karen Reed, taking over the airways. So no other good cases are streaming. I need to go do some research and see what trials in other areas are kind of going on that we can maybe watch. But I may not stream tomorrow, which means that I probably won't see y'all until Tuesday. It'll be a long weekend. I'll see y'all on Tuesday. I will still watch the Diddy trial and keep up and post an update, but I hope everybody have a safe holiday weekend. Shout out to everybody that's graduating. D Wood, make sure you tell your daughter the Taylor Gang said congratulations. Such a huge achievement. We are all proud of her. We proud of our niece. Tell her internet TT's got her. And we got her in our thoughts and in our prayers, and we know that it is going to be a wonderful ceremony. So shout out to D Wood and family over there, y'all. So make sure everybody have a good and safe weekend again, and I will see y'all later. Bye.